I just to mention for listing, okay, the divorce was filed by the husband in the court matter. There is an exploratory order. I just wanted to be challenged.
TRPIO.
Yes.
Monday. Monday.
Yes. Like to mention matter for the TRPIO.
Monday.
Monday. I'm great.
That is a matter pertaining to
The time for first is party order. Particular for
no, the matter pertains to what? It's RFA, FAO, what?
RFA. In
RFA.
connection with RFA.
RFA. Huh? Correction? Connection with RFA. Go and mention before the other court. I don't have RFA. There's another court, no? IA in RFA. So go before that court. There's another court, go there. Okay? Yes, what do you say about the efficiency part?
Yes. Lordship, this is the
You see, the concept of efficiency bar is like this. Once you reach the highest,
yes.
then you require an order
Lordship.
in order to get the increment.
Yes.
Normally, in other cases, you don't require.
Lordship, so for Lordship, here in this case, Lordship, the produce for allowing financial upgradation to an employee upon reaching of the maximum pay band has been prescribed at para 1, Roman 1 at page 287 of the Assam Service, Aro Payroll 2017. The matter is that when an employee reach the maximum pay band, she already reached on 2022. After that, after 2 years gap, his efficiency report will produce before the authority, and authority, if allow, he will get the next revised pay band.
That is what I am saying also.
Yes.
I am also saying that there will be a requirement of an order by them. And it is in fact a right which accrues for passing of an order. But that will only occur in 1st of July 2020, not before.
Yes.
That's it.
25th. 2 years after 24. Yes, right.
1st of July 2000.
Yes. That is the rule.
Anyway, the other side is not there. Let's see what happens. We'll have it on some other detail. Let's have it on 2nd of May.
2nd of May.
Okay. As the petitioner counsel is not represented, let's the matter again on 2nd of May. Yes, madam, your matter. Yes, how do you take care of that evidence?
My lord. Lord, when we had filed the suit, my lord, we had already laid a foundation because we were already under an impression that the grandfather of the father was a sub-registrar, and there was also a mutation procedure.
No. Have you mentioned anything in your pleadings?
Lord, if I may just indicate, Lord, so therefore we put a broad prayer in the claim that
No.
any document.
Forget about that. You now put a specific prayer in the plain book.
Yes.
my
Yeah.
amendment.
Yeah.
But have you mentioned anything about all these things?
I have not mentioned, my lord.
At the end, how
My lord,
could this court take into account those evidence?
my lord, this court can take into account, my lord. I'll just rely on a constitutional judgment, my lord.
Yes. Yes. What does it say?
My lord has 1966, my lord.
63.
63. 66. Yeah. My lord, because what I try to suggest is, my lord, paragraph 10 onward.
Yes.
My lord, first the rule of pleadings is cited, my lord. Paragraph 10, my lord. But in considering the application of this doctrine to the facts of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate considerations of substance. If a plea is not specifically made, and yet it is covered by an issue by implication, and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence. The general no doubt is that the relief should be founded on pleadings made by the parties. But where the substantial matters relating to the title of both parties to the suit are touched, though indirectly or even obscurely, in the issue and the evidence has been laid about them, then the argument that a particular matter was not expressly taken in the pleading would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know that the matter in question was involved in the trial? And did they lead evidence about it? If it appears that the parties did not know that the matter was an issue at the trial, and one of them has had no opportunity to lead evidence in respect of it, that undoubtedly would be a
Mr.
different
Counsel,
matter.
this is a matter pertaining to landlord-tenant. Now, how do you take care of Order 6, Rule 4?
My
It's
lord,
a case of fraud. It's a case of fraud where you have to mention specific pleadings.
My lord, I'm not. I have said I have not. I have said my grandfather did not execute it. So it could be a case of forgery also, my lord.
No. That is true.
Now, my lord will kindly consider
Mhm.
going by this ratio, my lord.
No,
There
no.
is a direct challenge to that deed.
That ratio, I think, better for the Supreme Court to decide.
My lord,
For this court, nothing to do.
my lord, I have a few more submissions.
Yes.
Now, my lord, the entire object behind this doctrine of sufficiency is to put the other side to notice, my lord, so that he's not prejudiced. Now, in this case, we have made a direct challenge to the deed.
So what?
They have filed an additional written
But
statement.
there is no mention why. There is no mention why you are challenging the deed.
My lord, I have already said that that particular deed is illegal and void. My lord, this is
You
something.
never said that. Where is your pleading to that effect that
Well-
it is illegal and void? There is not a single mention to that effect.
My lord, it is there in the record, my lord,
No,
the amended
nothing
thing.
is there.
Because I've said that that particular deed is illegal and void.
No,
I've said
only
it,
that's a relief. So
that's a relief, my lord.
why?
My lord,
Why?
it'll then be a question of form, my lord.
No, that's not. Hello.
And
Let me
my lord,
No.
few more things, my lord.
No, nothing more. I think this substantial question
Lord,
of law is there.
My lord, I'll just.
No, nothing more.
My lord will allow me to place the
No,
other.
nothing more. That is I have allowed you on the last
My
occasion.
lord, and secondly, my lord, was this plea ever raised throughout? My
Not
lord?
necessary. How
It
could
is,
this be raised?
therefore, I'll rely
No,
on the other
how can this plea be raised? How can this plea be very well raised at any point of time when You did not take a
They
plea in
have
your
filed
written
an additional
statement.
written statement
Even
against this
in your
particular plea.
amendment, you did not take the plea.
My lord, they filed a specific additional written statement answering this particular question, my
But
lord.
did you
They have
raise the
led-
plea?
They have led evidence, my lord, to suggest that he did not die in 1952. There is corroborative evidence to show
what?
that.
So what? How could the court take into account that? Not that court cannot have decided that sends the plea.
My lord, in this given the nature of the suit, my lord,
The nature of the
the
suit is
nature of
very
the
clear.
suit where the entire question hinges upon whether I had relinquished or not, they all of a sudden, my lord, I have no idea about it in the written statement, the producer document. I put a specific prayer, my
Then
lord.
you should have amended your plain to that effect that this is fraud. You have not mentioned. There's not a single allegation of fraud against the document.
My lord, I have said, my lord, they are the ones who are claiming on that document to say that the natural line of succession has been disturbed by this particular document. They have not even exhibited the signatures, my lord. They have not even exhibited the signatures. There's
The
not a single.
weaknesses of the plaintiff's case is not the defendant's case is nothing to. It is for you to prove it.
My lord, but given the nature of the plea is that the normal line of succession has been
Enough.
disturbed, and they.
Yes,
and then-
Mr. Dor, what do you have to say? On the second substantial question of law is his. You withdrew your counterclaim. Given. Care was given to them all. Yes. But I take your judgment passed by the trial. Yeah. Mr. Dhar, come here.
As per the pleadings or prayers made in the plain, my lord, one kedar, which is 1 foot chair of my lord, your lordship may kindly see, my lord, paragraph 16, my lord, of the trial court, your lord. Nothing has been given to us here.
What surfaces from the above discussion is the plaintiff side has been able to show that the plaintiff and the performer defendants
Performer defendants that
have
was the pleading,
right
my
and interest and possession over the land, right over and one kedar within the suit land, and 1/4 share in the house standing over the suit land as multi-right through inheritance in Ismaili, and the registered deed is fraudulent, collusive, and so and so. Both the issues are decided.
So-
How, if you have withdrawn your right
No.
or withdrawn your or abandoned your claim, yes, you could have very well asked yourself to be transposed out there. Because it is a suit against the defendant, there cannot be a counterclaim by a defendant against the defendant.
No.
There's no problem with that. But you should have asked for transposing yourself or joining out there. But that was not there. But with the plaintiff's case for failing in view of that release deed not being taken out.
I am not appearing for the performer defendant. My lord, I am appearing from the defendant number 2 to 11. Now, relief was given to the plaintiff and the performer defendant, 1 foot chair in the land. Now, my lord, the substantial question of law,
Who is 2 to 11?
in spite, my lord, as well as performance, my lord, substantial question of law, my lord, your lordship has framed now.
Hmm.
My lord, second substantial question of law. Whether the learned court below are justified in dictating the suit, thereby granting rights to the defendant, as well as performer defendant. In spite of defendants number 2 to 11 having filed counter claim and then abandoning their claims in terms of order law. But it appears that, my lord, some rights has been given to the defendants number 2 to 11 here. That was not given here. What was given, my lord? some rights were given to the plaintiff and the prosumer defendant. And that was the prayer of the, my lord, the plaintiff, my lord, themselves, your lord. Plaintiff said, if your lordship goes into, my lord, there, my lord, my lord, my lord, plaint, your lord. Now, plaint, your lord, you will find the prayer, my lord. Paragraph 16 of the plaint. 1. For declaration that the plaintiff and the prosumer defendant have their right, title, interest, and possession in landholder right over 1 kedar of land within schedule and 1 foot share in the house standing over the suit land as Maliki right throughout inheritance as Malik. That relief was given. So we are not given any relief, although, my lord, as per, my lord, paragraph 10 of the plaint, my lord, we are the co-sharers of the land. Paragraph, my lord, plaintiff and the defendant, they are the co-sharers of the land. My lord, I am not on all that. My submission is that, there it is a dispute between the co-sharers.
But you are not a plaintiff.
I am not plaintiff.
You did not file a counterclaim,
No, we have filed.
but you abandoned the counterclaim.
Abandoned.
So the question, your submission would be that you having abandoned, you have nothing to do with the land.
We are not given any relief, my lord. I am also not.
No,
praying for
therefore,
relief. We
the
are
relief-
there.
The
Yes.
relief which is being given would be only restricted to the performer defendants and the plaintiff.
And the plaintiff.
And-
And the
But
plaintiff.
the same has nothing to do, and you have abandoned your rights.
So, my lord, my submission is that, my lord, as it is a dispute among the co-sharers, your lord, it's appropriate, my lord, remedy for the plaintiff would have been, my lord, to file a partition suit, your lord, for, my lord, for the complete justice and all that, my lord. Here it is half-hearted, your lord, the suit filed by the plaintiff, your lord. And that, my lord, from that, my lord, all these discrepancies, whatever it is, has arisen.
Chalo.
And secondly, my lord, so far as this my lord, plaint was amended, your lord. Plaint was amended, and your lordship may kindly see, my lord, the judgment decree portion of the, my lord, judgment passed by the trial court, your lord. Now, your lordship may kindly see, my lord, decree. Plaint was amended. In the amended plaint, there was a prayer, your lord.
Hmm.
My lord, your lordship may kindly see, my lord, claims for page 3. Page 3, claim for. Now, so far as, my lord, first claim we know, then second claim we also know. 3, now, your lordship may kindly see paragraph 4. Italian 4, your lordship.
Page,
4, your lordship, of
Oh.
the decree. Handwriting. Handwritten, your
no, where is that?
lord.
In the
My lord,
report.
page 4 of the decree, paragraph 4.
Where is the decree?
Page 56. For declaration, have you looked for?
Yes.
For declaration that during trial, if the principal defendants number 1 and 2 bring jointly or severally any document denying right title of the plaintiff and the prosumer defendant over the suit land, the same shall be treated as illegal, inoperative, collusive, and cancelled. And for declaration, my lord, that is important. And for declaration that alleged deed of release number so dated 4/3/1952 of Karimgun's office is fraudulent, illegal, ab initio, void, inoperative, collusive, and cancelled. So that pleadings or prayers were there here. And accordingly, my lord, court had my lord, taken evidence, gone through the evidence, my lord, and passed the decree. And resting,
No,
my
no.
lord,
How could that evidence be taken into account since the pleading? Where's the pleading to that effect? That
my
you
lord,
see, how do you
unfortunately,
take care
I
of
do
Order
not have the
6 Rule
amended
4?
plaint to your lordship, but my submission is that, my lord, prayer is also a part of the pleading, my lord.
Understood. There is no quarrel with that. But when it is a case of fraud, you want to challenge the registered document. How do you challenge it? Challenge of the document has to be on the basis of fraud, coercion, or whatever. You are required to state material
my lord,
facts.
I have just submitted, my lord, that prayer was there.
No,
Now, so
the
far as
prayer would
amended
not.
plaint to your
You
lordship,
have not amended the plain. and stated you knew about this document. You never say that this person concerned was dead. You see, kindly appreciate.
I am told, my lord.
Well, no, Mr. Thor, kindly appreciate. The learned trial court, as well as the first appellate court, came to a finding that this person concerned is dead prior to the execution. How? There's not a single pleading to the effect.
My lord, we tried our best to obtain an amended, my lord, copy of the plain. I am handicapped, my lord, I did not get it. But what I have found, my lord, that ultimately...
No, I have seen. It is there on record. That is why, how did the case happen on that day? Why did I pray? While I was hearing the matter, I asked him.
So far, there's substantial question of law is, my lord, I am leaving it to your lord. Only, my lord, thing is that we are not...
And that is the basic. That hinges on everything. Once the release is, you can't touch it. Matter finishes. The plaintiff's case goes.
Only my lord, my submission is that, my lord, defendants number 2 to 11, they had submitted their written statement on the basis
They
of
will
their
be
written
abandoned.
statement, either the suit is to be decreed or is to be dismissed. Now here it has been decreed, my lord. But the substantial question of law, my lord, it reveals that we are given some right or share, although we have withdrawn our claim or counterclaim. That is not correct. We are not given anything.
Okay. But maybe not the defendant, but the performer defendants were given.
We are not, my lord. I am not performer.
Okay. The instant appeal. Do you have anything to say? No. Do you have anything to say? The instant appeal
My lord, Mr. Lord, can I take the plain for now?
is directed against the instant appeal under section 100 of the Code of Civil Procedure 1908 is directed against the judgment and decree passed by the learned court of the civil judge Karimganj entitled appeal number 43 of 2013 against the judgment and decree dated 28/8/2014 passed entitled appeal number 43 of 2013, whereby the appeal was dismissed, thereby confirming the judgment and decree dated 25/9/2013 passed by the learned Munsif number 1 Karimganj entitled suit number 213 of 2007. This court, by an order dated 8/12/2014, admitted the instant appeal by formulating 4 substantial questions of law, which are enumerated herein under. Order to correct. See? The instant appeal thereupon was heard at length by this court on 2/4/2024. And upon hearing, 2 additional substantial questions of law were framed, formulated, which reads as under. A1 and 2. Upon framing the said substantial questions of law, additional substantial questions of law, this court adjourned the matter for today, to be listed today. so that the counsels appearing on behalf of the respondents is given the opportunity to address on the said additional substantial questions of law so formulated. Next. For deciding as to whether the above substantial questions of law so formulated by this court initially on 8/12/2014 and subsequently on 2/4/2024 arises, or for that matter involved in the instant appeal, this court finds it relevant to take note of the facts leading to the filing of the instant appeal, which are briefly noted hereunder. Madam, take your seat. Take it. Yes, now give me the file. The appeal or file to decision. Appeal or the respondents numbers 1, 2, and 3 in the instant appeal proceeding as plaintiffs had instituted a suit during title suit number 213/2007. The case set out in the said plaint, in the plaint of the said suit, is that the original owner and possessor of the suit land which have been specifically described in the schedule to the claim was one Chandra Sharma, the said Dhirendra Chandra Sharma had two wives, namely Maloti Devi and Meera Devi. The father of the defendant number 1, as claimed in the suit, late Kamini Kumar Chaudhary, and the father of and the predecessor in interest of the defendant numbers 2 to 11, one Binod Bihari Talukdar, had taken a permanent tenure holder right and possession of the suit land from its proprietor, late proprietor Dhirendra Sharma Chandra Sharma, Maloti Devi and Meera Devi, to a registered deed number 2400 dated 29/3/1948, 1118 dated 29/3/1948, and 2401 dated 29/3/1948. The said right of permanent tenure holder and possession was acquired with the condition of payment of revenue and taxes regularly. The plaintiffs and the performer defendants claim to be successors in interest of the tenure holder, Kiran Chandra Chaudhary. And the principal defendant numbers 2 to 10, as already stated above, were a successor in interest of the tenure holder, Binod Bihari Talukdar. And the principal defendant number 11 is the successor in interest of the tenure holder, Indu Bhushan Talukdar. It was further mentioned in the plain that late Kiran Chandra Chaudhary was inherited by his two sons, Satyabrata Chaudhary and Bhaskar Chaudhary, and two daughters, Srimati Nivedita Chaudhary and Srimati Geeta Rani Chaudhary. Subsequently, Satyabrata Chaudhary died, leaving behind his wife Krishna Chaudhary, that is the performer defendant number 14, and his daughter Vaishali Chaudhary. The said Geeta Rani Chaudhary also died subsequently, leaving behind her two sons, viz. Bindu Bhushan Chaudhary and Tipu Sultan Chaudhary, who were also the performer defendants in the suit. The son of late Kiran Chandra Chaudhary, namely Bhaskar Chaudhary, also died, leaving behind his wife and son and daughter, who are the plaintiffs number 1 to 3. It was claimed in the suit that the plaintiffs and the performer defendants were heirs and successors of late Kiran Chandra Chaudhary in respect of 1/4 share over the suit land in Ismaili. Further to that, it was mentioned that the tenure holder, namely late Kamini Kumar Chaudhary, also subsequently died, leaving behind his only heir, the defendant number 1. Late Vinod Bihari Talukdar also died, leaving behind his 4 sons, that is the principal defendant numbers 2 to 4, and the predecessor of the principal defendant numbers 8 to 10, and 3 daughters, that is principal defendant number 5 to 7. And the said Indu Bhushan Talukdar also died, leaving behind his son, the principal defendant number 11. The basic case of the plaintiff, therefore, was as late Kamini Kumar Chaudhary, late Kiran Chandra Chaudhary, late Vinod Bihari Talukdar, and late Indu Bhushan Talukdar took permanent tenure holder right and possession over the suit land from its proprietor. The successor and interest of the said 4 tenure holders devolved upon acquired rights over the suit land. To the extent of 1/4 each. It was further mentioned in the plain that late Kamini Kumar Chaudhary and late Kiran Chandra Chaudhary were both brothers, and late Vinod Bihari Talukdar and late Indu Bhushan Talukdar were cousins. At the time of taking the permanent tenure holder over the suit land, late Kamini Kumar Chaudhary and late Kiran Kumar Chandra Chaudhary had their residence at village Hyala and Hyala, Hyala, and late Vinod Bihari Talukdar and late Indu Bhushan Talukdar had their residence at village Masimpur. Both the villages, that is Hyala and Masimpur, were within Sylhet district, which now falls and the territory of which and falls within the territory of Bangladesh. After the partition of India during independence, Late Kamini Kumar Chaudhary first came to India along with his nephew Bhaskar Chaudhary. Who was the predecessor in interest of the plaintiffs. And followed by them, late Kiran Kumar Chandra Chaudhary and his family members also came. The said Kamini Kumar Chaudhary and Kiran Kumar Chaudhary constructed dwelling house made of wooden posts, bamboo fencing and CI seats at the middle of the suit land and started living thereon with their family members. And presently also, and at the time of filing of the suit, the said house still stood over the suit land in a dilapidated condition. It was also alleged that both late Kamini Kumar Chaudhary and late Kiran Kumar Chaudhary dig a pond on the east of the said residential house and planted mango and trees over the suit land. Subsequent thereto, late Binod Bihari Talukdar and late Indu Bhushan Talukdar and their successors, who are the principal defendant number 2 to 11, also remain in possession of the suit land as per their right of tenure holder over the suit land in Ismaili. It was further alleged that late Bhaskar Chaudhary, who was the predecessor in interest of the plaintiff, resided in the suit land. And they paid the panchayat tax in respect of the house standing over the suit land. As late Bhaskar Chaudhary was working in the banking service, he also purchased a plot of land measuring 2881 square feet, lying on the southwest of lying on a bit southwest from the suit land. From one Gurupada Chaudhary through a registered deed number 8460 dated 1983. It was further mentioned that the principal defendant number one was the elder cousin of the predecessor of the plaintiffs. And the father of the principal defendant number one, late Kamini Kumar Chaudhary, was working as a sub-register. And as such, the plaintiffs and their predecessor, Bhaskar Chaudhary, were completely dependent upon the principal defendant number one and his father for payment of revenue, taxes, etc., and recording names of owners in the settlement records in respect to the suit land. It was further claimed in the suit that the plaintiff, as well as the predecessor, and the defendant number one had cordial terms. And the plaintiffs were enjoying 1/4 share in respect to the suit land. The plaintiff thereupon alleges in the plaint that the defendant number one, in connivance with others, was claiming the entire suit land by denying and depriving the right of the plaintiffs and the performer defendants over the suit land. Thereupon, the plaintiff number two rushed to the Karimganj and after collecting information could know that the principal defendant number one, 3, had filed a case, 103, number 257 bracket M of 2007 under section 145 and 146 CRPC against the principal defendant number one in the court of the SDM Karimganj. The plaintiff number two, after getting the necessary paper, thereupon could come to learn that the principal defendant number 3, as petitioner of the said proceedings under section 144, 145, and 146, claimed half of the share, that is the northern part of the suit land, and the principal defendant number 1, as second party, claimed the entire suit land. It was alleged that the principal defendant number one, by practicing illegality and fraud and misrepresentation, had inserted his name in the Khatian and Kachapatta in respect to the suit land and obtained an order by practicing fraud from the learned settlement officer Karimganj in Miss Case number 113 of 1994-95, dated 16/10/1995, to which the plaintiff and the performer defendants had no knowledge. On coming to learn, the plaintiff number two had submitted a petition in the office of the principal defendant number 12, praying to include his name, include the name of the plaintiff and the performer defendants in the record of rights in respect of the suit land. However, on account of the actions on the part of the plaintiff, principal defendant number one to claim the entire suit land and principal defendant number 2 to 11 to claim half of the suit land, and thereby denying the entire title of the plaintiff or as well as the performer defendants over the suit land. The suit was filed. Seeking declaration that the plaintiffs and the performer defendants have their right, title, and interest and possession in the landholder right over 1 kedar of land within the suit land and 1/4 share in the house standing over the suit land as multi-right to inheritance in Azmali, semicolon. For confirmation of possession of the plaintiffs and the performer defendant number 1 over 1 kedar of land within the suit land and 1/4 share in the house standing over the suit land in Azmali, semicolon. For declaration that the plaintiff and the performer defendants are entitled to include their name in the record of rights in respect of the suit land and to direct the principal defendant number 12 for correction of the record of rights in respect of the suit land in the said manner, semicolon. For declaration that during trial, if the principal defendant numbers 1 to 11 bring with the 1 to 11 bring with jointly or severally any document denying right, title of the plaintiff and the performer defendants over the suit land, the same shall be treated as illegal, inoperative, and collusive and cancelled. For perpetual injunction restraining, semicolon, for perpetual injunction restraining the principal defendants numbers 1 to 11 from interfering in the peaceful use, occupation, and enjoyment of 1 kedar of land within the suit land and 1/4 share in the house standing over the suit land by the plaintiffs and the performer defendants in Ismaili, and for other reliefs. Pursuant to the filing of the said suit, the defendant number 1 appeared and filed a detailed written statement wherein various preliminary objections were taken as regards the maintainability of the suit. In the said written statement, it was mentioned that late Kiran Chandra Chaudhary, late Binod Bihari Talukdar, and late Indu Bhushan Talukdar had no right, title, and possession over the suit land. And as such, the question of succession by the plaintiffs, the principal defendants, and the performer defendant over the suit, or any right over the suit land, did not arise. It was stated that late Kiran Chandra Chaudhary, late Binod Bihari Talukdar, and late Indu Bhushan Talukdar did not take settlement of the suit land from the ex-landlord, and hence the statements made by the plaintiffs in paragraph statements made by the plaintiff were totally denied. It was also mentioned that at the time of partition of India, as a sub-register government officer, Kamini Kumar Chaudhary, the father of the principal defendant number 1, opted for service under the government of Assam. It was denied that Bhaskar Chaudhary accompanied him. It was denied that late Kiran Chandra Chaudhary left East Pakistan, bracket Bangladesh, for good and shifted to Karimganj. It was denied that the members of the family of late Kiran Kumar Chandra Chaudhary shifted to the suit house at Karimganj. It was further stated that late Kiran Chandra Chaudhary, late Binod Bihari Talukdar, and late Indu Bhushan Talukdar never possessed the suit land. Late Kamini Kumar Chaudhary, the father of the plaintiff, resided in the suit land till his death in 1967. Thereafter, Surabala Chaudhary, the mother of the defendant number 1, resided in the suit house. And at that time, the defendant number 1 was in service under the NF Railway. And he would come to the suit house to reside there occasionally. After the death of the father and the mother, the defendant number 1 used to reside with the members of his family in the NF Railway quarters at Maligaon, Guwahati, and started to continue his exclusive possession of the suit land and the suit house through his caretaker and also through his tenants. The allegations of fraud as made in the claim, insofar as insertion of the name of the plaintiff or defendant number one in the record of rights, was categorically denied in the written statement. In paragraph number 4 of the written statement, the facts which actually happened was alleged by the defendant. It was categorically mentioned that late Kamini Kumar Chaudhary, that is the father of the defendant number one, took settlement of the entire suit land measuring 1.13 acre, equivalent to 3 bighas, 8 kathas, 6 chatak of homestead land appertaining to cadastral survey dag number 209 old of Khatian number 99, corresponding to cadastral survey number 233 new of periodic Pachapatta number 71, bracket revenue Kachapatta number 101 in Moza Chandri Kona Chak, Pargana Kushiarkul under police station Karimganj from the ex-landlord, that is Dhirendra Chandra Sharma, Maloti Devi, Meera Devi, by the registered deed number 1070 of 1948, oblique 2401 of 1948, and registered deed number 1118 of 1948. The late Kamini Kumar Chaudhary, as 100% owner of the suit land, with the knowledge of the predecessor of the plaintiffs and the principal defendant numbers 2 to 11 and the performer defendants, possessed the same from 1948 by constructing his dwelling house on a portion of the suit land. Semicolon or comma, had excavated the pond on a portion of the suit land and had also planted various trees and bamboo plants. On the basis of the title and possession of late Kamini Kumar Chaudhary on the suit land, the same was recorded in his name by the government in the first survey and settlement operations started in the year 1964 as cadastral survey number 209 under Khatian number 99 of Moja Chansri Kona Chak under police station Karimganj. Subsequently, on 23rd of December 1948, after due publication, the Khatian number 99 was prepared in the name of late Kamini Kumar Chaudhary and was finally published by the government. Where is the release deed mentioned?
S, my lord.
Huh?
Paragraph S, page 34.
Which one?
Lord, page 35 is the relevant code.
Which one? Read it.
We mentioned that Kiran Chandra Chaudhary, page 35, my lord.
Hmm.
Somewhere in the middle, we mentioned that here that Kiran Chandra Chaudhary, the predecessor of the plaintiff and the pro forma defendant of 14 to 18, relinquished his claim over the suit land by executing a registered deed of release dated 4th March 1952, registered by the sub-registrar Karimganj, wherein it has been mentioned by said Kiran Chandra Chaudhary that only Kamini Chandra Chaudhary took settlement of suit land, and said Kumar Chaudhary constructed the suit house and excavated the pond on a portion of the suit land and admitted exclusive possession of Kamini Kumar Chaudhary.
Why the need arose for this? You see, the deed which were there, 1070 of 1948, 2401 of 1948, and the registered deed number were in the name of your father.
Yeah, yes. Kamini Kumar Chaudhary.
Got it. Then why the need arose for the release deed?
Thereafter, that deed, we are not denying your lordship. That myself, my title is also not true. But the deeds are not denied by me. But after the execution of the deed, the question of the nazrama to be paid. That other three sharers, they never given the nazrama.
Understood. Then what happened? No,
Then
you say,
Kiran Chandra
Well,
Chaudhary,
have you exhibited those 1948 deeds?
Exhibit 1.
1, 2, and 3.
Oh. This 48 deed was in whose name?
4 persons names are there. Kamini Kumar, Kiran Chandra, Vinod Bihari, and Indu Bhushan.
Exhibit 1 is the first deed given by Maloti Devi and Meera Devi in favor of Kamini Kumar Chaudhary, who's Sri Kiran Chaudhary, so here Kiran Kumar Chaudhary signed it
Yes.
in 1948. Why are you saying that he never came? You are Kiran Kumar Chaudhary.
Yes.
How are you saying that Kiran Kumar Chaudhary never came?
He did not come for in 52, my lord.
No, 48.
48 he was there.
So he,
Well,
after
I'm not
partition
saying-
also he was there.
I'm not saying Kiran Chaudhary never came. They're saying he never came.
No. Whatever may be, I'm asking you,
My lord.
Kiran Chaudhary was there.
Kiran Chaudhary was there. He later shifted back to Haryana.
That we'll look in. First, Kiran Chaudhary was there in 1940.
48. He was there.
And the second is
Second is again by Meek Dev, Malodi Devi only.
these are the two deeds. Then this is the exhibit 3 is the
This is the Chandra Sharma, Dhirendra Chandra Sharma, Exhibit 3, 2401.
here also
Here
Kiran
also
Chaudhary
everyone,
was there.
everyone is there.
Then this thing happened. In 19,
These are 48.
Bhaskar Chaudhary. What is this document of Bhaskar Chaudhary? Exhibit 4?
Exhibit 4, my lord, I'm paying taxes, my lord.
No. Exhibit 8 then.
Exhibit is the
Exhibit
sale deed.
8, this is the document to show that Bhaskar Chaudhary was also residing in the house. He bought adjacent land.
He bought
Adjacent land.
for the nearby.
Nearby.
And what is exhibit 9?
Exhibit 9 is this is but this is also by Bhaskar Chaudhary. This is a sale deed in favor of Bhaskar Chaudhary from Guru Pada Chaudhary. Well, in fact, there exhibit 8 to 10 are those documents.
How did you get this document? This document at page 100 and is exhibited. That is an exhibit document. Exhibit 13.
That is the WS filed in the 144 proceeding.
And what is this? The next one, exhibit 14. Who is Anup Kumar Das Ukashta?
Relative of Devabrata Chaudhary. That time he was looking after the party. Now he is dead.
His prof, his chief.
is in another proceeding, I think, 145.
The entire 145 records are there.
And PW, how many are there?
Two.
Who are the two?
Borun Chaudhary, the plaintiff, and Sapan Kumar Dutt.
So your evidence of Borun Chaudhary
Yes.
is contrary to what you stated in your plaint. Because you said Kiran Kumar Chaudhary followed,
Yes.
and thereupon
Yes.
he resided.
Yes. Yes.
Now, in your evidence, you said that thereafter, say Kiran went back to the original homestead at village Hayala and then in East Pakistan for looking after the property, now Bangladesh, and died
Died
there
in the
in
year
1950. So this is contrary to your pleadings.
No, my lord. I just mentioned about him coming, my lord.
No. You said that he was
No,
steady.
I said that Bhaskar Chaudhary was staying.
You never said that Kiran Chaudhary left.
Kiran Chaudhary went back.
Did you say that?
No, that
Mr. Dekha, kindly, I know you are a good lawyer, but kindly don't play tricks with this court. Don't spoil your impression out here.
no, my lord, that
One has to be fair. I have already dictated what is there. So in that
What I'm saying
dictation
is-
out there, it is very clear from a plain that he came. First, Kamini Chaudhary came.
Chaudhary came. I'll read that
Then-
paragraph.
No, it's okay. I have dictated. I remember. Kamini Chaudhary came.
Yes.
Then second came the other person, Bhaskar Chaudhary, who accompanied Kamini Chaudhary. And then Kiran Chaudhary came. All together have erected the house, excavated the pond, and raised mango trees. Then comes the next one, the Indu Bhushan Chaudhary and the other person. Both of them come. There is not a single mention that he went back.
About his return.
There's no mention. Now you are saying that he went back and died in 1950 there. In your
Well, look, that but is an admitted position because they also say he died there. They also say
They are very categorical. They
Yes,
say,
they
no.
they
They
he
say
did not
he
come at all.
came and he went back. They say, not you. For you to say and went back, now you come up and say out here that he died in 1950.
And that they have also said. They have also said that he died. That they have also said.
No, you're right.
No, they
In the-
never
in the-
say
in
that
the-
1950 he
In
died.
145 proceeding is with 13 they said
What do they say?
that he died in 1950 in East Pakistan. Because there I was not a party. That's the whole problem, my lord. There it was a fight between my lord, the defendant number 2 to 11. Both of them were claiming their right.
That was a typographical mistake you lost it. Later on, that was corrected.
Lord, they were fighting amongst themselves. One was claiming half, the other was claiming entire land. When my question came, they said that I died in 1950 because I was not a part of the party to those proceedings.
So you are saying on this basis that he died in 1950?
Yes.
And what is this? This is a written statement.
Yeah, written statement filed by them.
So what? What is the effect of a written statement of another proceedings? That's not evidence.
It's an admission.
So it is not an admission in this court.
I'll just point it out. I just wanted to point out, this
That
is
is
what
not an
the,
admission here. It's not the evidence. Only a written statement.
exhibit 13. Paragraph B, 5B.
And you had this document.
Because I applied for the certified copy in
You had this exhibit 13.
Yes.
Then also you didn't say. You continued out there to say that Kiran Chaudhary always remained here.
Well, I also did not say that he remained throughout.
You said that.
I think, my lord, if
Read that paragraph. It's very clear.
I said after death of Kiran Chandra, my lord, one sec. Kiran Chandra, followed by them, Kiran Chandra Chaudhary and his family members also came. Said Kamini and Kiran Chaudhary constructed dwelling house made of wooden posts, bamboo fencing, CI sheet roof at the building of the Suitland and started living there on with their family members. Said homestead house is lying over the Suitland in a dilapidated condition. They also dig a pond on the east side of the residential, planted mangoes and other trees.
That's it. Thereafter comes Bhaskar Chaudhary's
Yes.
lineage. Then
After death of Kiran Chandra Chaudhary and his wife,
Then-
their sons.
after mentioning everything and then you say that Kiran Chaudhary died, can you now come up and say that no, he went back somewhere? That's not your case at all. You are to prove, not on the basis of such stuff. Anyway. At this stage, this court further finds it very relevant to take note of that the three documents which were mentioned in the written statement by which the rights, the tenure rights, permanent tenure rights were given. These rights were given to the said documents were made in favor of late Kamini Kumar Chaudhary, late Kiran Kumar Chaudhary, late Indu Bhushan Chaudhary, Indu Bhushan Kakar, what is his name?
Sadhu.
Indu Bhushan, so and so, and late Vinod Bihari Talukdar. It was further mentioned specifically mentioned that late Kiran Chaudhary, Chandra Chaudhary, the predecessor in interest of the plaintiffs and the performer defendant, relinquished his claim over the suit land, that is 1.13 acres, by executing a registered deed of release number 1186 dated 4th of March 1952. Bracket, registered by the sub-register Karimganj, bracket close, wherein it has been mentioned by the said Kiran Chandra Chaudhary that late Kamini Kumar Chaudhary took settlement of the suit land and late Kamini Kumar Chaudhary constructed the suit house and excavated the pond on the portion of the suit land and admitted exclusive possession of the said Kamini Kumar Chaudhary on the suit land. It was categorically mentioned that the plaintiffs, for their own benefit, had suppressed this material fact. The record further reveals that the defendant numbers 2 to 11 filed written statement with the counterclaim. From a perusal of the written statement cum counterclaim, it reveals that the defendant numbers 2 to 11 supported the case of the plaintiff. A counterclaim was filed along with the said written statement. Claiming declaration of their rights confirmation of possession, in respect to the Schedule 2 land as mentioned in the counterclaim. Schedule 2 and Schedule 3 land as mentioned in the counterclaim. Inasmuch as the defendant number 2 to 10 sought for the land specifically described in Schedule 2 and defendant number 11 sought for his rights in respect to the third schedule land. The record further reveals that on 27/8/2007, an application was filed the record further reveals that on 18/8/2008, an application was filed under Order 6 Rule 17 seeking amendment of the plain. Although there were various statements being made in the said application about the illegalities in respect to the registered deed of release number 1186 dated 4/3/1952. But the amendment which was sought for was only seeking amendment of the relief in para 16(4), thereby to include the declaration that the alleged deed of release number 1186 dated 4/3/1952 of Karimganj Sub-Registry Office is fraudulent, illegal, ab initio, void, inoperative, collusive, and cancelled. In addition to that, by the amendment, the enumeration of the facts mentioned in the plain in various paragraphs was sought to be inserted, was sought to be corrected. Thereby, reading the paragraphs 8, 9, 10, 11, 12, 13, 14, 15, and 16 should be read as paragraph 7, 8, 9, 10, 11, 12, 13, 14, and 15. This amendment application was allowed. Thereby, the amendments which was only sought for, that is insertion of the relief and the correction of the numbering, was permitted. The record further reveals that an additional written statement was filed by the defendant number 1 to the counterclaim. Additional written statement was filed by the defendant number 1. On the basis of the above, it is further relevant to mention that just prior thereto, on 18/12/2007, that is before the filing of the application seeking amendment of the claim, the defendant numbers 2 to 11 who have filed a counterclaim filed an application under Order 23, Rule 1 for withdrawal of the counterclaim. With the liberty to file an independent suit in order to determine the real question in controversy. Thereby, the learned trial court thereupon allowed the said withdrawal of the suit, counterclaim, with the liberty to file an independent suit by an order dated 10/1/2008. On the basis of the above pleadings, it is seen that the learned trial court framed as many as 7 issues. Issue number 6 related to whether the registered deed of release number 1186 dated 4/3/1952 is fraudulent, collusive, illegal, void, and inoperative document. And issue number 7, Roman 7, was whether the plaintiff and the performer defendants have their right, title, interest, and possession in respect to the land holder right over 1 cadre of land within the suit land and 1/4 share in the house standing over the suit land as multi right through inheritance in Esmaili. On the basis of the record for the reveals that on behalf of the plaintiff, 2 witnesses were examined and various documents were exhibited. And on behalf of the defendant, also 2 witnesses were examined and various documents were exhibited. Let me come back. Dated 25/9/2013, declared the suit in favor of the plaintiff and the performer defendant, thereby holding that the plaintiff and the performer defendant have right, title, interest, and possession in landholder right over 1 cadre of land within the suit land and 1/4 share in the house standing over the suit land as multi-right to inheritance in Esmaili, and the registered deed of release number 1186 dated 4/3/1952 was fraudulent, collusive, illegal, void, and inoperative document. In passing the said impugned judgment and decree, the learned trial court decided the issue number 6 and 7 in favor of the plaintiff. The learned trial court held that the Exhibit B, which is the deed of release dated 4/3/1952, by holding that the said deed was fraudulent, collusive, illegal, void, and inoperative document on the ground that the defendant in his written statement by holding by arriving at a conclusion on the basis that the plaintiff side had stated that late Kiran Chaudhary died in the year 1950. It was also opined that the DW2, that is the defendant, number one, had also stated in his evidence that late Kiran Chandra Chaudhary died in 1950. Did he? Mr. Deka, did he say?
My
In
lord,
his
I
cross.
could not read the cross-examination in Bengali.
Obviously, he did not.
May I, Your Lordship?
Hmm?
Your Lordship, in two parts, the DW2 process was taken. In one part on 8/3/30. 8/3/30. Here it is, he has mentioned that আমি শুনিয়াছিলাম কিরণচন্দ্র 1952 ইংরেজিতে মারা যান. Here he stated that he heard that Kiran Chaudhary was died in 1952. But in the later part of cross, again he changed his statement and he has written in Bengali, Kiran Chandra 1948 ইংরেজি পরে মারা যান. ইহা সত্য নহে যে কিরণ চৌধুরী 1952 সালে মারা যাননি, উনি 1950 তে মারা যান.
It is not a fact.
Yes.
That is a suggestion.
No, you are saying. This
This-
is suggestion.
That is a suggestion. The last part is the
Last part
is a
is 1950 তে মারা যান, but in earlier.
It is not a fact. It is সত্য নহয় না. It starts with the language. You see the language.
Yes, yes, Your Lordship. It is written something like that. ইহা সত্য নহে যে.
So it is a suggestion. So he denies that.
No, he is denying 1952 সালে মারা যান. Here he is saying our suggestion, but here he said that 1950 তে মারা যান. But in the earlier.
No. Madam, you are not understanding. The suggestion which was being put to him is this, that this Kiran Chaudhary was alive in 1948 but died in 1950. He says that it is not a fact that he died in 1950 or 1948. He died in 1952. That is what it is meant.
In Bengali, I am.
Huh?
In Bengali, I am also confused.
No, it is not a Bengali, you are confused. If it is in Assamese also, it is the same language. The problem is the question is being put to him in this manner. So he says that it is not a fact.
Yes. Yes.
In fact, he says in his chief, in fact, my uncle Kiran Chaudhary died in May 1952. So I submitted the petition dated so and so in the Court of Subdivisional for amendment of my written statement submitted. I have submitted a copy of so and so in so and so. Kindly see his cross down there. In his cross of this DW1, DW2, which is the portion written in English also. Executive Porter, so and so, Bottoman, so and so, down below. के जमीन আমি সূত্রে মালিক বলে উল্লেখ করেছি। এই লিখিত লেখা আছে সেই কিরণ চৌধুরী died in East Pakistan and died there as a citizen of East Pakistan in 1950. এ এটা ভুল লেখা হয়েছিল। You get it? Therefore, he says that. So he affirms that what he has stated out there. almost the last portion of DW2's cross read it. Start with Exhibit B. এটা সত্য নহয় যে Exhibit B এটা চূড়ান্ত দখিল নধৰি ভাষাৰ সীমা স্থাপন। Read it, last portion,
Yes, Your
the last portion. Just where it starts everywhere with Exhibit B. The first word is
Lordship.
Exhibit B, page 13. Page 13 out there. I think you have taken a photo certified copy. Yes. See Exhibit 13. Give it to me.
Exhibit B.
Give it to me. I'll show you which. You have the entire portion of the cross. Seems to be the entire thing. No. What are you reading? This is some Bhakanta Kumar Roy. We are concerned with the other one, no? DW2. No, who is DW2?
Question to
No, Debabrot Chaudhary.
DW1.
No, think that, not this. He is who? Another person. He is no business. Why are you reading this? That is what I was finding. Give me DW2, DW1. You don't have. How much help can a court give it to you? You come up with 4 questions of law which have no relevance. I frame it. Then, thereafter, you don't come up, we don't know who is the main person. And you don't have it. Is this the manner of preparation of a second appeal? You have it?
I
Give it to me. That is what I was not finding it. Yes, yes. Yes, read it from here. Hey, take on. Read it from. Yes, read.
Exhibit B তে কিরণচন্দ্রের ঠিকানায় জেলা চিহ্নের পর দেশ পূর্ব পাকিস্তান লেখা নাই। এক্সিবিট বি দ্বিতীয় তফসিলের জমির মোয়াজি হিসাবে 2.5 কেয়ার 6 জ্যোতি 1 কোয়া ভাড়া মাত্র উহার দক্ষিণের অর্ধেক মোয়াজি 5 কোয়া জ্যোতি 15 ঘন্টা লেখা আছে। এক্সিবিট বি এর 5 কোয়া 3 জ্যোতি 15 ঘন্টা দক্ষিণাবর্তের জমি কিরণচন্দ্র চৌধুরী দাবি করে কিনাই তাহা আমার জানা নাই, কিন্তু আমি জানি তিনি সম্পূর্ণ বাড়িতেই তার দাবি পরিত্যাগ করেন নাই। এক্সিবিট বি দলিলেও তপস্যের সম্পূর্ণ বাড়িতে ত্যাগ করেন তাহা নিয়ে তেমন কোনো লেখা নাই। এক্সিবিট বি দলিল মারফত কিরণচন্দ্র চৌধুরী কতটুকু জায়গার মুখ্যপত্রেও তাহা দলিলে লেখা আছে, তবে দলিল পড়িয়া আমি বলিতে পারবো না, কারণ সে বিষয়ে আমার অভিজ্ঞতা নাই। ইহা সত্য নহে যে এক্সিবিট বি দলিল একটি যোগাযোগ দলিল
পুলিশি।
এবং কিরণচন্দ্র তাহা সম্পাদনাও করে নাই। ইহা সত্য নহে যে এক্সিবিট বি দলিলের বয়ান মিথ্যা।
হ্যাঁ?
ইহা সত্য নহে যে দিস ইজ নট আ ফ্যাক্ট দ্যাট এক্সিবিট বি ইজ এ ফ্রড।
Then?
ইহা সত্য নহে যে এক্সিবিট বি দলিলে কিরণচন্দ্র চৌধুরী কারণ আসল কিরণচন্দ্র চৌধুরী। ইহা সত্য নহে যে এক্সিবিট বি দলিলের কিরণচৌধুরী কারণ আসল কিরণচন্দ্র 1950 সনে মারা যায়। ইহা সত্য নহে। দিস ইজ নট এ ফ্যাক্ট দ্যাট অরিজিনাল কিরণচন্দ্র চৌধুরী ডাইড ইন 1950।
This is your line. You are reading from Basantara. Then come further. This is the most important. He is DW2. He's not DW1. This person is DW2. He is DW1. Yes. Then?
এবং যার জন্য আমার তা সাবরেজিস্ট্রারের সহিত যোগাযোগ করে নিজেই পরিচয়কারী হয়ে এক্সিবিট বি মিথ্যা দলিল বানায়। And this is not a fact. এক্সিবিট বি তে প্রথম পৃষ্ঠায় প্রথম তফসিলের ভূমি বলে যাহা লেখা আছে তার দ্বিতীয় পৃষ্ঠায় এই তফসিলের ভূমি। ইহা সত্য নহে যে এক্সিবিট বি দলিল দ্বারা কিরণচন্দ্র চৌধুরী না লিখা জায়গায় কোনো তথ্য পরিত্যাগ করেন না। he has not relinquished his part.
Then
ইহা সত্য নয় যে নালিশা জায়গায় আমার পিতা 1/4 জায়গার অংশীদার এবং বাদীরা অন্য 1/4 জায়গার অংশীদার এবং বাকিটা বিনোদ বিহারী তালুকদারের উত্তরাধিকারীরা সত্যবান।
so he never said so. And you kindly come back to another portion of his clause. That is what I am saying. Huh? Kindly come to read that portion. It starts with an executive court. Give it to me again. Hey. Read that. This is the most relevant portion.
Exhibit A,
No, not there. Down below, executive court.
করিমগঞ্জ এক্সিকিউটিভ কোর্ট। করিমগঞ্জ এক্সিকিউটিভ কোর্টে বিকাশ রঞ্জন রায় আমার ও মণিশঙ্কর চৌধুরীর বিরুদ্ধে একটি ফৌজদারি মোকদ্দমা করে, যার নাম্বার 257M of 2007 under section 145, 146 CRPC। সেই মোকদ্দমায় প্রথম পক্ষ এক্সিবিট 1, 2 এবং 3 এর ফটোকপি দাখিল করেছিলেন। এই মোকদ্দমায় আমি ও মণিশঙ্কর চৌধুরী একসাথে যৌথ জবাব দাখিল করেছিলাম। সেই জবাব 18/6/2007 সনে আমি দাখিল করি। সেই জবাবে সেই মোকদ্দমার ডিসপিউটেড ল্যান্ড সহ সর্বমোট 1.13 একর জমি আমি মৌরসি সূত্রে মালিক বলে উল্লেখ করেছিলাম। সেই লিখিত জবাবে লেখা আছে, Said Kiran Chaudhary lived in East Pakistan and died there on a citizen of East Pakistan in 1950। তবে এটা ভুল লেখা হয়েছিল, যার জন্য আমি সংশোধনী দরখাস্ত দাখিল করি। 24/9/2007 সনে সেদিন সেই মোকদ্দমার কোনো ধার্য তারিখ ছিল না। পরবর্তী কোনো আদেশে সেই মোকদ্দমায় এই সংশোধনী দরখাস্তে কোনো উল্লেখ নেই। এক্সিবিট এম দরখাস্তে কোনো নম্বর বা সিল বা সই নেই আদালতে। ইহা সত্য নয় যে এক্সিবিট এম কাগজটি অরুণ চৌধুরী জবাব দেওয়ার পর আদালত চত্বরের কিছু নিজ মানুষের সহযোগিতায় সকল পক্ষের অনুপস্থিতিতে সেই মামলার রেকর্ডে দূর অভিসন্ধিমূলক প্রবেশ করাইয়াছে। এক্সিবিট এম দরখাস্তের কপি অন্য পক্ষের উকিলকে দাখিল করা হয় কিনা তাহা আমার জানা নেই, আমার উকিল জানবেন। মোকদ্দমা নাম্বার 257M of 2007 এ আমি কোনো সাক্ষী দেই নাই। বাদীপক্ষ কোনো সাক্ষী দিয়েছে কিনা আমার জানা নাই। এই মোকদ্দমা ড্রপ হয় কারণ বর্তমান কেস নাম্বার 213/2007 চলছিল। মণিশঙ্কর চৌধুরীর পিতা গুরুপদ চৌধুরী ও তার পিতা রঞ্জু চৌধুরী নামেও পরিচিত। রঞ্জু চৌধুরী মারা যায় এই মোকদ্দমা হওয়ার পূর্বে, কিন্তু 10 বছর হয় নাই এখন। রঞ্জু চৌধুরীর বাড়ি নালিশা জমি থেকে পশ্চিমে কামাখ্যা বাড়ির উত্তরে, কিন্তু রাস্তার পশ্চিম। তাহা নালিশা জায়গা হইতে দক্ষিণ পশ্চিম কোণায়, কিন্তু একটু দূরে। পিডব্লিউডি
Okay.
রাস্তা
Done. No. And who is this Basanta Chaudhary? DWP?
Principal defendant number 11.
He is Vasanta Chaudhary, defendant number 11. Who filed the written statement against you? He filed a written statement against you and making a counterclaim.
Yes, yes.
He's against
They're
both.
jointly.
He's against both.
He has claimed that he filed
He
a written
claims that the suit should also be dismissed and he is entitled to Schedule 2.
under. So he is nothing to do with DW1.
No, he's Indu Bhushan's son.
Therefore, he's being believed by the learned trial court as it has been given by the DW. Kill. Died in the year 1950. Merely on the basis of the statements made by the plaintiff, which is, however, not supported by any pleading, the learned trial court opined that Kiran Chandra Chaudhary expired in the year 1950. On the other hand, though, the defendant, witness number 1, exhibited 2 numbers of account sheets in respect to the Shraddha ceremony of Kiran Chandra Chaudhary. But the said documents which have been exhibited as Exhibit Q and Q1 were disbelieved as being weak piece of evidence. Further to that, the learned trial court opined in connection with section 34(3) of the Registration Act 1908 and observed as nobody identified Kiran Chandra Chaudhary and the sub-register having observed that late Kiran Kumar Chaudhary was known to him was not sufficient. And further opined that the registration of the alleged deed of release dated 4/3/1992 was not in accordance with law. On the basis of the decision, primarily in respect to the legality and validity of the registered deed of release number 1186 dated 4/3/1952, the issue number 7 was decided, thereby granting the plaintiff as well as the performer defendants their right, title, and interest and possession as landholder over 1 acre of land within the suit land and 1/4 share in the house standing over the suit land as Malki right through inheritance in Ismaili. Being aggrieved, an appeal was prepared by the defendant number 1 before the court of the civil judge, Karimganj, which was registered and numbered as title appeal number 43/2013. The learned First Appellate Court dismissed the said appeal by confirming the findings of the learned trial court in respect to Exhibit B. On the ground that by holding by placing reliance on Exhibit 13 and coming to an opinion that if late Kiran Kumar Chaudhary had expired in the year 1950, how could he execute Exhibit B after 2 years? Unlike the learned First Appellate Court, a trial court, who held that the DW2 admitted that Kiran Kumar Chaudhary died in the year 1950. Unlike the learned trial court, who held that the DW2 had stated that late Kiran Kumar Chaudhary, unlike the learned trial court, which held that the DW2 had stated that late Kiran Kumar Chaudhary expired in the year 1950. Who stated, had admitted that late Kiran Kumar Chaudhary had expired in the year 1950. The learned First Appellate Court goes a further step and holds that the DW1 had admitted that late Kiran Chandra Chaudhary expired in the year 1950. It is further observed by the learned First Appellate Court that the executant of Exhibit B was not identified by the independent witness, and the sub-register had mentioned that he knew the executant personally. However, there was no explanation as to how the register was acquainted with Kiran Chandra Chaudhary, who was an inhabitant of Sylhet. On the basis thereof, the learned First Appellate Court came to an opinion that there was no illegality or error on the part of the learned Munsif while answering the said issue in favor of the plaintiffs, and affirmed the decision of the learned Munsif in respect to issue number 6. This court further takes note of that the learned First Appellate Court also held in respect to the issue number 3, which was the issue pertaining to limitation, and held that the suit was governed by Article 58, 59 of the Limitation Act, inasmuch as the PW1 in his evidence had stated that he came to know about the existence of Exhibit B after getting Exhibit 13. It is under such circumstances that the said appeal was dismissed and has led to the filing of the instant appeal, instant proceedings under Section 100 of the Code. In the backdrop of the above, let this court therefore decide as to whether the substantial questions of law so formulated by this court are involved in the instant appeal. The first substantial question of law is as to whether a degree of confirmation of physical possession can be passed in respect of any unspecified and unidentified share of an immovable property of a joint owner although there are 6 substantial questions of law formulated by this court. But this court is of the opinion that for this court, it is the opinion of this court that a decision in respect to the additional substantial question of law number 1 as framed on 2/4/2024 would have a necessary bearing on the other substantial questions of law so formulated, for which this court takes up the additional substantial question number 1 for adjudication. The said substantial question of law so formulated was as to whether the learned court below were justified in taking into account various evidence which were beyond the pleadings in coming to a finding as regards issue number 6. In the previous segments of the instant judgment, this court had in detail recorded the stand of the plaintiff in the plaint, as well as also the amendment which was sought for to the plaint. In the plaint, there is not a single whisper as to when late Kiran Kumar Chaudhary expired. On the other hand, it has been categorically stated at paragraph number 6 of the plaint that late Kamini Kumar Chaudhary and late Kiran Kumar Chaudhary were own brothers, and they resided at village Hyala, Hyayala, now presently in Bangladesh. It was further stated that after partition of the land, partition of India during independence, late Kamini Kumar Chaudhary first came to India along with his nephew, that is the predecessor in interest of the plaintiffs. This was followed by thereupon late Kiran Kumar Chaudhary, Chandra Chaudhary, along with his family members, came to India and constructed dwelling houses made of wooden posts, bamboo fencing, and CIC troop at the middle of the Suitland, and started living thereon with the family members. It was further mentioned that late Binod Bihari Talukdar and late Indu Bhushan Talukdar and their successor in interest successors, that is the principal defendant, also came over and remained in possession of the suit land as per their right of tenure holdership over the suit land in Ismaili. It was categorically stated that after the death of late Kiran Chandra Chaudhary and his wife, their sons and daughters, that is the predecessor of the plaintiff and the performer defendant number 16, and the predecessor of all other performer defendants were in possession of the suit land. There is not a single whisper in the plaint that the late Kiran Kumar Chandra Chaudhary went back to Bangladesh or had expired in the year 1950. Although a further perusal of the plaint clearly shows that the plaintiffs filed the suit after the plaintiff number 2 made inquiry and came to learn about the proceedings in CR 257M of 2007. Wherein the defendant number 1 had claimed rights over the entire suit land. This court further finds it very relevant to take note of that even in the amendment application so filed, on 18/8/2008, pursuant to the written statement filed by the DW1, wherein it was filed by the principal defendant number 1, wherein it was categorically mentioned about the deed of release and the date of execution of the deed of release. There is no mention whatsoever that at the time of execution of the said registered deed of release, late Kiran Kumar Chaudhary was not alive. Further to that, the amendment which was sought for in respect to the plain was only for the insertion of the relief. Was only for the amendment of the relief in paragraph 16 Roman 4. And in view of the amendment, it became paragraph 15 Roman 4. However, in the evidence on affidavit filed by the PW1, he makes us change from, now he takes a completely different, he portrays a completely different picture to what was content in, with what was stated in paragraph number 6 of the plaint. And further, and state that after coming to India, late Kiran Chandra Chaudhary and his family members and constructing the house, digging the pond, and planting various kinds of trees and bamboos thereon, went back to the original homestead at the village Hiala, then East Pakistan, for looking at the property, and died there in the year 1950. There is no document whatsoever mentioned, have been brought on record to show that late Kiran Kumar Chaudhary expired prior to the execution of the deed of release, that too at East Pakistan, except laying emphasis on the written statement filed by the DW by the principal defendant in the proceedings number 257M of 2007 under section 145, 146 of the CRPC. Wherein the defendant witness number 1, wherein the principal defendant had stated that in his written statement, that written statement in those proceedings, that late Kamini Kumar, late Kiran Chandra Chaudhary expired in the year 1950 in East Pakistan. The the plaintiff witness number 2 had nothing to say in that regard. Now, if this court duly takes note of the provisions of Order 6, Rule 4 of the Code of Civil Procedure, it would be seen that the said provision is a departure from, makes a departure from the normal law of pleadings, which is stipulated in Order 6, Rule 2. Inasmuch as Order 6, Rule 2 only mention that a pleading shall contain a concise statement of material facts on which the plaintiff party pleading relies for his claim or defense. As the case may be, but not the evidence by which they are to be proved. Whereas a reading of Order 6, Rule 4 stipulates that in all cases in which a party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary, beyond such as are exemplified in the forms mentioned in terms with Order 6, Rule 3. Particulars, bracket, with dates and items, if necessary, bracket close, shall be stated in the pleadings. Let me come back. The Constitution Bench of the Supreme Court in the case of Ladli Prasad Jaiswal versus the Karnal Distillery Co. Limited, Karnal and others, reported in AIR 1963 SC 1279. Observe that Order 6, Rule 4 of the Code provides that in all cases in which party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in any other cases in which particulars may be necessary beyond such as exemplified in the forms in the appendix, particulars with dates and items, if necessary, close, shall be stated in the pleading. The Constitution bench further observed that the reason of the rule is obvious. A plea that a transaction is vitiated because of undue influence of other parties thereto, gives notice merely that one or more of a variety of insidious forms of influence were brought to bear upon the party pleading undue influence, and by exercising such influence, an unfair advantage was obtained over him by the other. The object of the pleading is to bring the parties to a trial by concentrating their attention on the matter in dispute so as to narrow the controversy to precise issues and to give notice to the parties of the nature of testimony required on either side in support of their respective cases. The Supreme Court was further categorical in observing that a vague or a general plea can never serve this purpose, semicolon. The party pleading must therefore be required to plead the precise nature of the influence exercised, the manner of the use of the influence, and the unfair advantage obtained by the other. This rule has been evolved with a view to narrow the issue and protect the party charged with improper conduct from being taken by surprise. Therefore, it was also observed that a plea of undue influence, like fraud, must serves to a plea of undue influence must, to serve that dual purpose, be precise, and all necessary particulars in support of the plea must be embodied in the pleadings, semicolon. If the particulars stated in the pleadings are not sufficient and specific, the court should, before proceeding with the trial of the suit, insist upon the particulars which give adequate notice to the other side of the case intended to be set up. The Constitution bench further referred to a judgment of the Privy Council in that regard. In the case of Vishnu Dev Narayan versus Siogini Rai, and Jagannath, Jagrnat, reported it AIR 1951 SCR 548. wherein it was observed that there is one rule which is better established than any other. That is, that in case of fraud, undue influence and coercion, the party pleading it must set forth full particulars, and the case can only be decided on the particulars as laid. It was further observed that there can be no departure from them in evidence. And general allegations are insufficient even to amount to an averment of fraud of which any court ought to take notice, however strong the language in which they are couched may be, and the same applies to undue influence and coercion. In the instant case, coming back to the instant case, it would be seen that there is no pleadings whatsoever as regards any fraud, undue influence, or coercion. There is not even any mention, whisper, that late Kamini Kumar Chandra, went back to East Pakistan and died in the year 1950. There is no allegations in the pleading. No, not Kamini, Kiran Chaudhary. Kiran Chaudhary. There is no allegations in the pleading that the deed of release so executed by late Kiran Chandra Chaudhary was executed by some other person as an imposter. There is no allegation to constitute. There is no allegation that in the pleading that late Kiran Chandra Chaudhary could not have been identified by the sub-register alone. And as such, the registration, if any, without following the procedure, was bad. This court also finds it very pertinent to mention that the deed, which has been dated 1952, which has been exhibited as Exhibit B, at the time of being exhibited, was 30 years old. And therefore, there is a presumption in favor of the said deed insofar as its execution as well as registration. This goes further. Moving forward, this court finds it further relevant to take note of. Another very vital aspect of the matter, which touches on the additional substantial question of law. Number one, as to whether sense in the pleadings, the evidence could have been at all taken into consideration. In the case of Binod Kumar versus Sujit Kaur, reported in AIR 1987 SC 2719, 219, 2179, the Supreme Court observed that the pleadings of the parties form the foundation of their case, and it is not open to them to give up the case set out in the pleading and propound a new and a different case. In the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SCC 148, the Supreme Court categorically observe upon making copious detail of various other earlier precedents. That a relief not founded on the pleadings cannot be granted. A decision of a case cannot be based on grounds outside the pleadings of the parties, and no evidence is permissible to be taken on record in absence of the pleadings in that respect. The Supreme Court further went ahead to observe that no party can be permitted to travel beyond its pleadings, and that all necessary and material facts to be pleaded by the party in support of the case set up. And where evidence was not in the line of pleadings, the said evidence cannot be looked into or relied upon. Paragraph number 77 and 78 of the said judgment, being relevant, is reproduced hereunder. In the same judgment, the Supreme Court further, at paragraph number 85.6, observed that the court cannot travel beyond the pleadings, as no party can lead evidence on an issue, oblique point, not raised in the pleadings, and in case such evidence have been adduced or finding of fact have been recorded by the court, it must be just ignored. The said paragraph is also reproduced hereunder, 85.6. At this stage, this court finds it very relevant to take note of. The judgment of the Supreme Court referred to by the learned counsel appearing on behalf of the respondent. That is, in the case of Bhagwati Prasad versus Chandramool, reported in AIR 1966 SC 735. It has to be understood in the said suit. In the said case, it was a landlord-tenant dispute. The question of involvement of any allegation of fraud, coercion, undue influence, which are special cases falling within the ambit of Order 6, Rule 4, was not an issue in the said case. The learned counsel appearing on behalf of the respondent, numbers 1, 2, and 3, place reliance on paragraph number 10 of the said judgment to the effect that if an plea is not specifically made and yet it is covered by an issue by implication, and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle the party from relying upon it if it is satisfactorily proved by evidence. In the opinion of the court, the said judgment is misplaced, taking into account that that in the instant case there is no plea even by implication raised in the pleadings. This court further finds it very relevant to take note of that this judgment came up for consideration before the Supreme Court in a recent judgment in the case of Srinivas Raghavendra Rao decided by LRS versus V. Vinod Vaman Rao, Elias Alok, and others, reported in 2024 INSC 165. Wherein the case involved was relating to whether the partition of 1965 could have been taken into consideration. And there was a specific submission being made on the basis of the judgment in the case of Bhagwati Prasad Supra, that the parties going to trial knew the issues involved, the evidence led, even without pleadings, can be well appreciated. The Supreme Court categorically observed that there was no quarrel with the proposition of law that no evidence could be led beyond the pleadings. It further went on to observe that in the same case, it was not a case. In the same case before the Supreme Court, it was not a case in which there was any error in the pleadings and the parties knowing their case fully well had led evidence to enable the court to deal with the evidence. In the same case, specific amendments were sought for in the pleadings with reference to the 1965 partition, but the same was rejected. And as such, it was observed that in such a situation, the evidence with reference to the 1965 partition could not have been considered. The same principle, if applied to the facts of the instant case, it would be seen that on the basis of when was the suit filed?
2007.
7. On the basis of the pleadings contained in the written statement about Exhibit B, that is the deed of release dated so and so in public 1952, dated so and so. The plaintiff sought for amendment of the plaintiff, but did not insert any of the statements, but did not include any pleadings to that effect. As to on what basis the plaintiff alleges that the Exhibit B, that is the deed of release, was a fraudulent document. Merely the plaintiff only inserted, sought for an amendment to the relief sought for. In the backdrop of the above proposition of law and the analysis, if this court now takes up the judgments passed by both the learned trial court as well as the first appellate court, it would be seen that the learned trial court as well as the learned first appellate court took into consideration certain evidence which were not there in the pleadings, which had no basis in the pleadings, to nullify the deed, registered deed of release dated so and so, that is Exhibit B. The learned, both the courts below further went into the question of Section 34 of the Registration Act 1908, without there being any pleadings to that effect, that late Kiran Chaudhary never appeared before the register, before the sub-register, to execute the registered deed of release. There is no allegation in the plaint that late Kiran Chaudhary could not have been identified by the sub-register, or the sub-register could not have been identified by the sub-register as he was a resident of East Pakistan. In fact, the stand taken in paragraph number 6 of the claim of the plaintiff makes it very clear that that late Kiran Chandra Chaudhary was residing at Karimganj. Under such circumstances, in the opinion of this court, the learned trial court as well as the learned first appellate court was completely was not justified in taking into consideration the fact of the death of the consideration, the evidence of the death of late Kiran Kumar Chandra Chaudhary in the year 1950. This court further finds it very relevant to take note of another very important aspect of the matter. It will be apparent from a perusal of the judgments of both the learned trial court as well as the learned first appellate court. Inasmuch as a perusal of the judgment of the learned trial court, it was opined that the DW2, who was the defendant number 3, had admitted that late Kiran Chandra Chaudhary expired in the year 1950. Whereas the learned first appellate court opined that the DW1 had admitted that the said defendant witness had admitted that the late Kiran Chandra Chaudhary expired in the year 1950. However, nothing of such is discernible in the evidence of DW1. Or even the cross-examination of DW2. Further, the DW2's evidence could not have been taken into account. Further, the evidence of the DW2 could not be, nothing is discernible. Huh? Is not discernible from the evidence of DW1 and or DW2. This also touches on the perversity in the appreciation of the evidence by the learned court, by the learned first appellate court as well as the learned trial court. Inasmuch as certain aspects have been taken into consideration which was not there on record. Considering the above, this court is therefore of the opinion that the additional substantial question of law number 1 is duly involved in the instant appeal, for which the judgment and decree is involved in the instant appeal. And consequently, as the same touches on the very, and consequently, the impugned judgment and decree passed by the learned first appellate learned courts below, by the learned first appellate court, by the learned courts below, stands set aside and quashed, is required to be interfered with. Next. You don't press the other questions of law now. Do you?
Yes, sir.
You want to press other questions of law?
Based on the second one,
Which one?
who is the honorable court will pray.
No, not me. The 4 substantial questions of law which have been played.
The issue it's already part
The
of
learned counsel appearing on behalf of the appellant submits that in view of the adjudication of this court on the on the additional substantial question of law, the substantial questions of law so formulated on 8/12/2014 loses significance, and as such, the same are not required to be gone into. Next. In view of the above, let this court now take up the additional substantial question of law number 2 as to whether the same is involved in the instant appeal. This court, in the previous segments of the instant judgment, had categorically observed that the defendant numbers 2 to 11 had filed a written statement come counterclaim. Subsequent thereto, on 18 12/2007, the said counterclaim was withdrawn with liberty to file an independent suit in order to determine the real question in controversy. The records further reveal that on 10/1/2008, the learned trial court permitted withdrawal of the said counterclaim with liberty to file an independent suit. Under such circumstances, in the backdrop of the above, if this court now takes up the second additional substantial question of law framed on 2/4/2024, in the opinion of this court, the same is not involved in the instant appeal, inasmuch as the counterclaim so filed by the defendant numbers 2 to 11 was withdrawn with liberty which was duly granted. And as such, the same would not amount to abandoning the claim subject to permissibility in filing an independent suit. In addition to that, this court also finds that the decree which was been passed by the courts below was a decree only in respect to the rights of the plaintiff and the performer defendants and not the defendants. Number 2 to 11. Consequently, this court, therefore, is of the opinion that the second additional substantial question of law is not involved in the instant appeal. Consequently, this court, therefore, sets aside the judgment and decree dated 28/8/2014, passed in title appeal number 43/2013, passed by the Court of the Civil Judge Karimganj, and consequently, in view of the merger of the said merger of the judgment of the and decree dated 25/9/2013 to title suit passed in title suit number 213/2007, in the judgment and decree dated 28/8/2014 in title appeal number 43/2013, the judgment of the trial court also does not survive. The appeal is allowed with cost quantified at 25,000 for the instant proceeding. Further, the appellant would be entitled to costs throughout the proceedings. And return debts. Yes, madam, take it. Last year matter. But this is Mr. Dhar, I have clarified it.
Right.
There's nothing out there.
We have departed,
Huh?
We have departed to fight the separate. We filed
Yeah, and partition suit, there is no limitation.
Our Millard, yeah, since these are all admitted matters. We are going by the plate I have said. I mean, these are somehow admitted. So there is no partition to start without the remedy in this case. When they admit, plaintiffs are also admitting, and about some extent.
Right.
Yes. SAO. What is this SAO is to do?
It was remanded to the trial court under order 1.
Under order 41 rule,
26A, without any discussion.
entire thing. Why?
Kindly see, alert page 47, judgment of the court.
Starts and finish.
Yes.
This appeal is directed against the suit for
For
Manish.
Manish,
Repay the judgment and file by 50. Yes. So it's for the first appellate court to decide. What is this? Isn't it the final court of facts, law and facts?
My lord.
Everything is open.
But to decide all the documents and issues, my
So
lord,
what is the problem? Every document and issues are all there.
17 years they have kept it pending, my lord. By this time, the suit and the appeal would have been disposed of. 2007, this has been stayed. And now it's 24, my lord. And my lord, my suit is of 1998.
No, but this court cannot do anything else.
Well-
This court can't
But
decide.
even your lordship,
Either it has to go before the trial court
my lord,
or it has to go before the first appellate
first
court.
appellate,
But
But
Mr.
why
Roy Chaudhary,
my lord,
don't you think that you should accept it?
my lord, I
Do you
understand.
know why? If you accept it, one round is gone.
But I also lose one option, my lord. If it doesn't go to
Now, after 17 years, you want to have another option.
because if it is gone to the trial court, I would have got the first appellate. It would have been taken.
No, you have given your everything.
Only
Did you
everything-
require? Is it the only ground why it is required? Is either you frame a fresh issues for which evidence is required. There's nothing,
I
nothing
understand.
mentioned.
Nothing.
No.
Then-
But only thing is that within a time frame, my lord.
Therefore, next Thursday, what am I doing is getting hold of all these old FAOs and SC, and an advance list will be coming up tomorrow. These matters will be taken up by me on Thursday next, and I will be finishing up because these matters require an early disposal.
My lord, I understand.
And the sad part, I'm finding out all these SAOs. I've asked the registry to find it out. There are 40% of SAOs which are actually RSC. 40% SAO which are actually RSC.
RSA.
And
Regular
it has
sale.
been no question of law.
No question. The lordship may give only a time frame that the appellate court will decide.
Yes, that is the best way. This is an appeal under Section 104, read with Order 41, Order 43, Rule 1U. 1U
1U.
of the Code of Civil Procedure 1908 against the judgment and order dated 2/3/2007, by which the money appeal number 1/2006, by which the learned district judge at Karimganj in money appeal number 1/2006 remanded the matter in accordance with Order 41, Rule 23A of the Code for a fresh trial by the learned trial court. Yes, any judgment on that? There are many judgments. Na? One should
I have
not
brought.
deliver.
Oh, your lordship.
Not mine. Don't bring mine. I don't tell.
Not one judgment. If the lordship will-
1983.
As of now, today, even after almost 2.5 years have gone, I have not relied on one judgment of mine. Yes. Yeah, the High Court decided that,
But-
which you want. after 17 years for me. No, this is not the case. Anyway. This court have perused the impugned order dated 2/3/2007. And from a perusal of the said order, it does not show the reason why the learned First Appellate Court had remanded the matter back to the learned trial court. That too when the learned trial court was, the learned First Appellate Court could have decided the said appeal on its merits, being the court of facts and law. In the opinion of this court, the said order is in contravention to the provisions of Order 41, Rule 24, isn't it?
My lord.
What does it say? When all evidence is there, the court should do it, isn't that?
20. My lord, order 41, rule 23A, even though trial court decide all issues.
No. Order 41, Rule 24.
25 also,
No, not 25.
where appellate court may frame,
No, not 25.
or 24, where evidence on record sufficient.
Ah,
Court may,
yeah. It is in confirm, which is contrary to the provisions of Order 41, Rule 24 of the code. And as such, the impugned order dated 2/3/2007 is set aside and quashed, and the learned First Appellate Court, that is the learned court of the District Judge Karimganj, is directed to decide the appeal on its merits on the basis of the materials which are already available on record. This court have duly taken note of that the parties herein are duly represented, are represented before this court. Accordingly, the parties are directed to appear before the learned court of the District Judge Karimganj on 3/6/2024. I don't know record. On 3/6/2024. The registry is directed to forthwith transmit the records of the file of the case remit the LCR to the court of the District Judge Karimganj, and if need be, by resorting to a special messenger, so that on the next date so fixed by this court, the learned First Appellate Court, that is the court of the District Judge Karimganj, is in a position to take up the said appeal. This court further is of the opinion that the appeal, further of the opinion that a suit which was filed is of the year 1998, and almost 26 years have passed. Under such circumstances, this court requests the learned District Judge Karimganj to make an endeavor to dispose of the said appeal as expeditiously as possible, and if preferably within a period of 6 months.
All right.
better for this one for and the record back to record further evidence by the order at 21. Nothing has been done by the
What?
order dated 21 2020.
2020. What did you say?
there are three. As per I think keeping of plaintiff claim over 10 by Harto exceed 1 certificate. The prejudice of exhibit 1 certificate shows that the section of the land which is stated in the form of Cozy number and account number and not in the form of any tag number or photo number. As per plain schedule, land is described in tag number 5 and 70 of final question number 3. Presently in Kalimba city. It says that
What, you filed an application for what?
no, it's no court, my lord.
How? Why did it send it back?
Or according to this, my lord.
Why? Did anybody file any order to a hotel? Then what is this? This order, forget about that. While being a lawyer, I was even asked by the court to file an evidence on affidavit in a second. Yes, tell me, what is the substantial question? Judgment of the learned court below are perverse to the fact of the case in coming to a finding that Exhibit 7D is not specific because dark number are not mentioned, although exhibit contains the Cozy number and account number of different plots of land, which clearly prove the appellant purchased the entire Kalinga estate and the suit land. Whether the judgment of perverse being not passed on pleadings and evidence on record, that is. And why there are two appeals?
Separate, my lord.
Why?
Two cases that are two.
Dependents are different.
Different.
Dependents are different.
Why there are two cases?
Some different plots, lordship we are possessing. The dependents.
You are possessing land
Yes,
of the.
lordship we have purchased. Our case is that we have purchased. Their case is that they have purchased by the exhibit 1. And both the court said exhibit 1 does not have any dark number and lordship.
Cozy number is there.
Cozy number is there, but that does not tally with the land which we are occupying, lordship. On that ground, lordship, both the cases were dismissed. And earlier also 2 regular second appeal are pending before this case. Those were already dismissed. Supreme Court also dismissed.
In respect to same matter.
No.
Same facts
No,
and
that's
circumstances, lordship,
This is
only different plots of land.
Different.
But the same goodwill
Here-
company against some other person.
Here, my lord, they have taken
Now,
the
why there are two appeals?
two different persons to
Okay, let us first take up
160.
160. There is some other Guttu and company
Yes, sir.
My lord.
issue notice. What is that? Why this has been shown? Is it dismissed? This Guttu and company.
Guttu and Company 161 RSA oblique 2007 that was dismissed.
161.
Yes, lordship. And another one 159 2007 lordship.
It is pending.
Both are dismissed, lordship.
Both are dismissed. Where is the
Yes.
both? You have given only 159.
Lordship, I
61.
have obtained only one 59.
Anyway, we can find it out. Don't worry. Both are dismissed.
Supreme Court about 159 I have no idea, lordship. 161 I have given this copy, lordship. Supreme Court's order. 161 dismissed in this court and Supreme Court also.
Now, this question is different.
It's a different, my lord.
It has nothing to do with this. Here, the question is very specific, isn't it? 161, what is the question involved? Let's see. Whether we have committed grave error in rejecting the sale deed in favor of the appellant merely because the deed of favor of AR was not exhibited when the suit land is and was not when the suit land is the part and parcel of 20. How is it relevant? Anyway, let me come back in 5 minutes. We'll finish it off. These matters need to be finished. Guttu and Company is the plaintiff here also.
Yes.
Me too, Jane, Guttu and Company. And who are the defendants there? Respondent, same.
Oh,
No.
no, lordship.
It's different.
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 Here, the question is different.
Yes.
Here the question is whether on the ground of Cozy Moza are perverse on the fact of the case in coming to a finding that Exhibit 7 deed is not specific because dark numbers are not mentioned, although Exhibit 7 contains the Cozy. Now, as to whether the Exhibit 7 has any relevance, let me come back in 5 minutes. We'll just come. Why the limitation point was taken?
The third question.
Huh?
Third question.
Party Our party is there.
Then 30 years, mother there.
No. How did you take the limitation?
Lordship, we are possessing since
No. It's
1984.
a different thing. The
That's
moment
it.
are you claiming adverse possession?
No, Lordship, 1980, they said that 1998 we dispossessed the plaintiff. On that ground that we are possessing since 1984 by party.
So how does the point of limitation have any relevance? Unless you are claiming adverse possession. Let me see the plain.
Let me get
There is a paper book. That
one, one,
160 paper book. 160.
one, one, one. Right. Then
How did your predecessor get your right? From whom?
We have purchased from 3 different parties.
Understood. How did they get the right?
Lordship, that was not stated in the written
That
statement.
is the most India. Don't you think that you have to show the nucleus?
Lordship. But first, the plaintiff, Lordship, their suit was not, land was not identifiable as per issue number 2. Lord.
Hmm?
Issue number 2 was discussed that the plaintiff suit land is not identifiable. And then issue number 6 was discussed.
Why it was said to be not identified?
Trial court judgment. Your Lordship. is
Trial
saying
court
once-
says many things. I'm not on that. Land pertaining to settlement dark number 70
I do.
of final Khatian number 3 of Moza Kalinga Jungle block number 2 in Fargana Garaswati of erstwhile district of Kachar, now Karimganj, and corresponding to resurvey dark number 90 of Patta number 18, rounded by east west the land of the plaintiff and the Kalinga tea state corresponding to settlement dark number 20.
In all the boundaries, only plaintiff's land was mentioned.
Hmm?
All the boundaries, Lordship, in the plaintiff.
Obviously, you are in between. On the record of title number, title appeal or RSA 160.
Description of the suit land as per schedule, Lordship, land pertaining to settlement survey dark number 70
160.
of final Khatian number 3.
उनके वो फाइल What are the documents you exhibited, Mr. Savala?
My lord, we have
Certified copy of some deed, Exhibit 7.
7. That was proof in original. And the Saudi, my lord, is there. It exhibit, my lord, 1. That we have proved that tag number 70 is there, my lord. Exhibit 1. Exhibit 2 also.
Where is the schedule?
Schedule. Then pertaining to settlement survey tax number 70 of final question number 6. Puja Kali, triangle block number 2. Paragana, Sati, Asal, Kasar, now Panimba, corresponding to the survey number 90. Bounded on boundary has
Where? Boundary?
yes, boundary is there. In the schedule. Bounded,
Where is the schedule which have been transferred?
right?
Now, how did you prove that this land fell in Tozi number 16 and 17? Tozi number 23 also has been shown. Many Tozi.
Well, the entire Kalinagar picture paper.
Understood. How did you prove that this land which is there falls within these Tozis?
Well, the entire Kalinagar is there, well, okay, so that is why, well, the entire, you'll also see, well, the first exhibit 1, well.
Where is the exhibit? Yes, what is it? It is proved in original.
Yes.
Huh? Rights acquired by the government under the 57.
Yes.
Was this a part of it?
No,
How do you say so?
Act number 70. Act number, all is original Act number 70, now it is 9.
Huh?
Now it is 9. Second.
Now, after this,
Yes.
which dog has gone now remained with you after this? You were asked to retain certain land, no?
On the 5 and 70, we have retained that.
How do you know?
But that has been, we have stated, fellows, and there, the T224 also states.
Hmm?
T224 also states.
How?
My lord, the T224, my lord, is a, my lord, I mean, of the sealing branch of the Deputy Commissioner. And in his cross examination, he has said,
DW4.
Yes.
DW1 or DW?
T224 in cross examination. They have got that this land has gone as sealing charter. But now, 3 years post, my lord, his evidence has come to consider. Prosecution. I got to actually follow so it's fact number 5 and 70 are the idea of witness from the extent of it.
Wait. To the extra writers published DW1. DW2. DW4 is the Amin Commission. Amin.
Yes.
Okay, I'm working as the Amin in the sealing branch of the Deputy Commissioner. On someone I have instructed to appear with the record of so and so out of dark number 70, an area of 252 bighas, 14 hectares were made sealing surplus, but I cannot say whether they were demarcated. In dark number 5, an area of 61 bighas, 11 years were acquired as sealing surplus. I cannot say whether the same were demarcated from the rest of the land. The Xerox copy of the state case showing the cast land and the retainable land equivalent to the original and under objection. According to exhibit C, column number 20, so dark number 5 and dark number are the area retained land of the garden. Column number 28 in dark number 78 and 5. See, the area of excess land as per exhibit C, there is no demarcation between excess. None of the required garden. You did not bring any revenue authority
No, my lord.
to identify that this land. But the fact is, how did they get right over the land?
My lord, they actually in para 10 they have taken a plea of adverse person, not in.
Hmm.
My lord, para 10. Thereafter they say they purchase. Hello, how they purchase? How this person owner who become the owner? Asking they have to show, my lord, that the seller has the right.
Hmm?
Seller has the right to sell.
Hmm.
The owner. That is not there. And they have been taken unsigned dependence is the period of limitation. That is since about 30 years past before purchase or garden by the Kalinagar constructing the outside planting tree has been positioning the land in assessment by the right title interest. There. That is why my lord is
Now, unless they show, how did they get the owner? How did you get the title? You
My
merely making purchase won't do. How did you
purchase
get the title?
deed we have exhibited, Lordship, exhibit B, C, D. And we said that
So
we have.
tomorrow I sell of Taj Mahal and all, and tomorrow can Mr. Sahewala I sell Taj Mahal to him. Can he say that okay, I got it from him, so he's okay?
No,
First
Lordship,
you have to show that I also have the title as regards the Taj Mahal.
Lordship, in
It's
the
something
written
like that.
statement, it is clearly stated that apart from dock number 70 and 5, Lordship, some other lands, Lordship, Bharat Samiti sold out to Kalinagar Tea Estate, and then Kalinagar sold it to Lordship Guttu and Guttu Company. But dock number 70 and 5 were never sold out by the Bharat Samiti, Lordship. It is mentioned in para 4, Lordship.
The DW categorically says, DW, your witness in cross
Lordship.
categorically says that that is in the name of the company.
No, Lordship, that is not the dock number 70 and 5, Lordship.
Yes, that is what has been stated in the cross. Kindly see here.
DW1,
cross.
Lordship.
The cross. Owner of the land of Dag number 5 and 7 of Kalinga Jangal area is the garden. Then the garden was sold to him. Various sources has been mentioned.
Lordship, out of dock number 70, an area of 25 2 bigha, 252 bigha, 14 katha were made ceiling surface. But I can't say whether they were demarcated in dock number 5, an area of 61 bigha, 11 katha, 2 chota were acquired as ceiling path. I cannot say whether the same was demarcated from the rest of the land. A xerox copy of the said showing the proved in original as exhibit, which cannot be this. According
Now,
to exhibit,
therefore, this land,
Lordship,
you are in 5 and 7.
yes,
Your claim is on 5 and
5
70.
and 7.
It has to be, if it is, it originally belonged to the tea garden.
Lordship, that was made ceiling surplus and then it was
Understood.
Lord.
So the question is, there has to be a settlement being made in your favor,
in favor
your
of my
predecessor.
vendors, Lordship.
Where is it? You have not proved that.
Lordship, that was
Then-
pleaded.
Without that document, it will be nobody. And kindly see here, Further, as per the record, the possession of the excess land of the Dag are not shown to be surrendered to the government. As per the record, there is no order to show that the excess land has been made khas by the government. And if it is not made khas by the government, then under such circumstances, the question of allotment under 16 does not arise. And if it does not arise, your predecessor could not have got that land. This evidence is
The
in
dark
against
number
you.
70 and 5 were made ceiling surplus, Lordship.
Understood, but then also the settlement has to be given.
Lordship, it was pleaded in the written statement,
No, forget about that.
Lordship.
Has the settlement been given? The settlement has to be given on the piece of the paper. Merely by stating that there is a settlement would not do, because then section 91 hits in.
That was exhibits, actually. It's a pretty old pending case. The
Huh?
exhibits I do not have. I have to go through the FCR.
I've seen the exhibit.
Lordship.
There's no
ECDM,
document to
I
that effect.
purchased it. That
That is what I'm saying. What you have exhibited are these. See. And you see, both the courts below completely misunderstood how to deal with the tea garden land. You see, the tea garden land is in vast lands, and you cannot make out where it is, and there cannot be a boundaries to that effect. It will be just given in a dark number or a patta number. Some in cases, only the patta has been given out there. Earlier to that, recently only they are having certain thing. Now they have the patta in their name, and that patta, the katta patta which has been enclosed out there, kindly see, this is the katta patta which enclosed dark number 5.
for
And
that,
dark
Lordship,
number
revenue appeal
70,
was preferred.
where is 70? 70, and that has become new 90. And where the total land is how much?
380 bigger.
380 bigas. 38. 38 bigas.
No, sir.
No, it is 153 bigas, 8 katha,
Yes,
8,
150.
8 chataks,
Yes.
8 kathas,
8 kanda.
yes, 4 gandas or something. And then we come to tag number 5.
Five.
That is also 136.
Para call, Lordship, about ceiling surplus land that was pleaded by the written defendants. Lordship.
Understood.
And
Let us assume that the person has got it.
Lordship.
If he has got it, he has to prove it. Now, what is this? See, Perform Bhumi আর রাজহ আয়ান সোয়েন্ট অনুগ্রহ করি সোয়েন্ট আলী ইমান ইমান
And in respect to the recording of name of the company in the revenue records, Lordship, one revenue appeal was preferred, Lordship.
That is a different thing. We're not on that. But where is your settlement?
That
The
ceiling case
settlement has to be
1991,
made in your favor.
ceiling case of 1991, 92.
Ah.
So the question of prior to that does not rise. Ceiling case of 1991, 92.
Yes, 91, 90.
91, 92.
And you purchased it prior to that.
Yes.
Lordship.
How is it?
1984, our purchase dates, Lordship.
Then, and that person, how did he get it prior to that? 84. How could you have purchased the land from somebody?
Lordship. Some of the lands were made ceiling surplus. That is
Understood,
Lordship.
madam. Everything is understood. Feeling surplus, but you have to prove how your person has got the title. The ceiling surplus happened in 1991, 92.
Lord.
How did you have a deed of sale from somebody in 1984 when that land was very much belonging to them? Let us see what was told. In the tea garden lands, these people, they don't know how to do it. And that has now become dock number 90.
70
And you have given the 4 boundaries.
Yes.
That land has to be then shown from there. That this is the land.
Yes.
He's in occupation.
Yes. Yes.
And if he cannot show a better right
Yes.
over the land which is in dock number 5 or dock number 70, that is the land.
And their evidence is that their vendors got the settlement.
Where is the
Allotment of the-
settlement?
That's it. How that is.
Chalo, let us dictate it.
If your lordship take up this matter on Tuesday, lordship, in the meantime, we can go through the exhibits, but another second appeal is also pending.
Hmm?
The next one is also pending, lordship, the RSF 4.
Same.
Company
Yeah,
and
same.
dependents
Almost.
different, lordship,
And there is 8, 5 and 70.
lordship.
Yes.
What is the question frame? Same. Many questions. So issue number 4, the substantial question number 4. And DW4's evidence is clear.
Hello?
The DW4's evidence is clear in
Clear.
your case.
Yeah.
Chalo. What to do? It.
Both the cases I am appearing, lordship.
Eh?
Close it up. In both the cases I am appearing, but only I have not gone through the exhibit.
That your lookout, you know it's in the top of the list. Because you see, this court doesn't have the time or the luxury on Tuesday. Tuesday there will be again some other matter. And Mr. Sahewala's matter is there na, on Tuesday.
Yes.
Then there's another matter. So every day there is a lot of problems in every matter. Not so easy. Once it doesn't goes out from this court, you become
Thursday, your lordship. Thursday at 2 p.m. lordship.
Thursday again take another long list of SAOs and FAOs, which I'm taking up.
Your lordship can pick it at 2 p.m.
When?
Thursday. Or any motion days, maybe it is not possible. Motion days, it is not possible.
Heard in part, it's the matter again on Tuesday at 2 p.m.
Lordship, if your lordship allows me, I go through the record.
The file is there, you go. We take it. Problem, madam, arises is because of there is nothing out there. You can't say that I have a sale deed. How? How did you get the sale deed in respect to a land unless there is a settlement by the government?
That settlement pleading is there, whether any evidence they have adduced or not.
Nothing.
That I,
And DW and your witness spoils
Not-
your case.
Not-
Without that DW4, you had a good case. The failure on the part of the plaintiff you have supplemented. It is something like yesterday's matter. The truth was the appeal is otherwise the impact says you want to make it good appeal.
okay.
Yes, next. Madam, you look into those evidence.
Wait, wait,
Hmm.
in this case, lordship, the playing appellant is the defendant number 3, the plain suit. He was working the separate police. So he gave one party in a case whereby the name of the petitioner was name of the village of the petitioner was wrongly. Accordingly, I'm sorry, plaintiff. Accordingly,
You are a plaintiff.
and the defendant.
So what happened?
The defendant number 3, that is the appellant.
What is the case of the plaintiff?
In this case is due to a wrong search and action by the police. He was
Wrong?
wrongly arrested. The plaintiff was wrongly arrested. He claimed for compensation by issuing notice to the defendant. They have not paid, therefore they filed the suit claiming compensation money
From?
from the defendant number 1 and 2. Both are
Who are the defendant number 1 and 2?
defendant number 2 and 3. Defendant number 1 is the state of Assam, who is the person who arrested the
Where is the plaintiff?
plaintiff. Yes, sorry.
Plaintiff?
Yes.
Huh?
Yes,
6.
start from page 7, paragraph.
Money suit.
Number 1 is the state of Assam. Number 2 is Ikakoti.
Officer in charge.
At
Number 3 is sub-inspector.
that time,
For tortious damages, compensation on or about demand for wrongful false confinement. Then
that suit was agreed. The defendants were
why? How did the plaintiff suffer? You wrongfully arrested him.
I took the third seat and the defendant number 2 wrongfully arrested.
You are who?
At that particular time of the
Who are you? Defendant number 3.
I'm defendant number
You did not file your written statement.
I-
It's shown as ex parte.
who is expert?
3 is ex parte. Torun Chandra Das. Who is Torun Chandra Das?
I'm the defendant.
Did you submit your written
Yes,
statement?
Lord.
Where?
Number export is number 1. Sorry, Dr.
So is the written statement filed on behalf of all the defendants?
Number self and on behalf of defendant 2 and 3.
Torun Chandra Das.
Therefore, self and on behalf of the defendant number 2 and
So you arrested pursuant to a warrant.
that's the person to
Then how does the learned trial court?
defendant number 2, not by defendant number 3. I'm the number 2. Arrest was done by defendant number 2, not by defendant number 3. I'm defendant
Okay.
number 2.
What is the issue framed? Number 4.
4 and 5 are Starts at page 5, internal page 5, page 20, regarding it.
Now, what has happened to the charge sheet?
What is happening according to that case was proceeding. The the plaintiff was arrested due to the 30.
What has happened to the charge sheet?
This is their case has been instituted.
What has happened to the charge sheet as of now?
I think for
Mr. Sharma, are you, what type of assistance is this to the court?
because due to the 30 case, their case was initiated on the basis of that.
Have you read the judgment of Bhajanlal? Or is the Bhajanlal judgment is somewhere foreign, is in United States? Where? Have you read the judgment? When a suit can be filed on the ground of what do you call vexatious complaint? When? When can a suit be filed? No.
I have read it, but
We'll do one thing. We'll dismiss the appeal for default.
no,
We'll dismiss the appeal for default because of the fact that the council does not know head and tail about law. Law and Mr. R. Sharma are poles apart. For what?
that law.
Huh?
In this case, it's simple to pay the plaintiff claim for compensation, and in this case, my case.
Both courts have granted that.
Yes.
Then why should we interfere? At ends,
In this case,
we dismiss it.
there's a question of there's liability count.
We dismiss it. 2 lakhs is 2 less.
No, Lord, put granted only 30,000.
How much?
30,000.
30,000.
Yes.
And you are filing a second appeal. State of Assam.
No, Lord. This
Well,
is by the Barton contract. Then number 3 on this leave the capital.
we arrest him wrongfully and then this is done. Hello.
May see the
Hello.
30th part.
It's okay. We dismiss it.
May see the
This
30th
is an appeal
part.
under section 100. Challenging the judgment and decree dated 9/10/2007, passed in Money Appeal number 2/2007 by the learned District Judge Punitpur, thereby affirming the judgment and decree dated 21/4/2004, passed in Money Suit number 36/2000 by the Court of the Civil Judge, Senior Division, Punitpur at Tejpur. The instant appeal was admitted on 11/1/2008. We do one thing. We will dismiss and impose a cost of 50,000. So make it 30 plus 50. 50 is the interest. This court, by an order dated 11/1/2008, admitted the instant appeal by formulating two substantial questions of law, which reads as under. For the purpose of deciding as to whether the said substantial question of law, which have been formulated, arises or is involved in the instant appeal, this court finds it relevant to take note of briefly the facts leading to the filing of the suit. The plaintiff herein, the respondent herein as plaintiff, had instituted a suit against the state of Assam as well as two other officials who have been arraigned as defendant number 2 and 3. The case of the plaintiff is that the defendant number 2 and 3 wrongfully
the question of whether that defendant number 3 is wrong in submitting the certificate for which the plaintiff was arrested.
Mr.
May I kindly see the
Your, I have heard.
May I kindly see the certificate?
Not illegally last plaintiff. Wrongfully arrested the petitioner inasmuch as the said defendant ought to have arrested one Sri Madhavda of Holiamari. It was the further case that the respondent number 2 and 3 have also falsely implicated the plaintiff in respect to Jamuguri PS case number 41/97, dated 23/3/1997. On account of the above, the plaintiff sought for a decree for damages for wrongful and false confinement of the plaintiff from 3/9/1999 to 10/11/99, and thereby claimed an amount of rupees 1 lakh each from the defendant number 2 and 3. And the defendant number 1, another amount of rupees 2 lakhs. Pursuant to the filing of the said suit, which was registered and numbered as Money Suit number 36/2000, the defendants jointly filed a written statement stating in the earlier that on completion of the investigation, the case was charge sheeted against one Sri Madhav Das, showing him as an absconder. Madhav Das, alias Ting Ting. It was also mentioned that the investigating officer, that is the respondent number, defendant number 3, that is who is the appellant herein, made all attempts to arrest the main accused and also inquired about the whereabouts of the said person. And it was learned that the accused was a man of dangerous character who had no particular place of business as well as the place of stay. It was further mentioned that as per the process register of Jamuguri PS 1999/2000, a bailable warrant of arrest was received from the learned CJM, Tejpur, against Madhav Das alias Ting Ting,
Is important here.
son of Kumeswar Das.
It was submitted by the arrest was made after the stop of
Fixing 17/9/99. In pursuance to the court's order, the officer in charge of Jamuguri police station, who was the defendant number 2, executed the non-bailable warrant of arrest against Madhav Das, alias Ting Ting, on 5/9/99 and produced the warranty before the learned CJM, Tejpur, on the same day.
this person's address is different.
It was mentioned that it was that the arrest of the plaintiff must have been made wrongfully on a probable presumption that the name of the father of against whom of Sri Madhav Das alias Ting Ting was Kosari Das and not Kumeswar Das.
See the name of King King, that's also not of the plaintiff. It is reflected in document of the trial court.
On the basis of the above, it was submitted that the case set out by the plaintiff for compensation did not arise, as the same was done in the charge of the official duty. On the basis of the pleading, as many as 6 issues were framed, of which issue number 4 related to as to whether the defendant number 2 and 3, being employees of the defendant number 1, acted irresponsibly in implicating and falsely arresting and wrongfully detaining the plaintiff from 3/9/99 to 10/11/99. And the issue number 5 was as to whether the plaintiff was entitled to the decree as prayed for. The learned trial court, while deciding the issue number 4 and 5 together, after taking into account the evidence on record, came to a finding that the defendant number 2 and 3, being the employees of the defendant number 1, acted irresponsibly in implicating, falsely arresting and wrongfully detaining the plaintiff from 5/9/99 to 10/11/99. Accordingly, an amount of rupees 30,000 was imposed as damages, which was to be paid jointly by the defendants as compensation. Being agreed, an appeal was filed by the appellant herein, challenging the said judgment and decree, which was registered and numbered as Money Appeal number 2/2007. The learned first appellate court, after duly taking note of the materials on record and also applying the provisions of order and applying the provisions and in consonance with the provisions of Order 41, Rule 31 of the Court, dismissed the said appeal by affirming the said judgment. At this stage, this court finds it very relevant to take note of that the state of Assam, who was also equally responsible to abide by the decree, did not file any appeal against the same. Be that as it may, in view of the concurrent findings of facts arrived at and the dismiss and the suit having been decreed, which have been affirmed in the appeal, the present appeal has been filed which was been admitted by this court by formulating the 2 substantial questions of law which have already been quoted here in above. In the backdrop of the above, this court have heard Mr. R. Sharma, the learned counsel, appearing on behalf of the appellant. None appears on behalf of the respondent. Let this court therefore take note of as to whether the 2 substantial questions of law which have been formulated arises in the instant appeal. The first substantial question of law relates to as to whether the courts below were justified in holding the appellant liable to pay compensation in an action for damages for the alleged tortuous act of the appellant, because the act complained of was submission of a charge sheet in discharge of his official duty in the case capacity of an investigating officer. This court have duly taken note of that the learned trial court, this court have duly taken note of the written statement filed by the defendants wherein at paragraph number 8, it was categorically mentioned that appellant, who was the investigating officer, made all attempts to arrest the main accused and also inquired about the whereabouts of the said person. This court further takes note of that the plea which have been the basis on which the instant substantial question of law have been formulated, have been raised, proposed to be formulated and accordingly formulated. There is no foundation of the same in the judgment of in the pleadings. Apart from that, this court is also of the view that the learned trial court as well as the learned first appellate court have duly considered the various aspects of the matter in the proper perspective, and as such, and categorically held that the appellant as well as the officer in charge, who was the defendant number 2, had acted irresponsibly. The same being findings of facts, in the opinion of this court, cannot be disturbed in the proceedings under section 100 of the code. The second substantial question of law is pertaining to perversity for non-consideration of the material evidence that the name of the accused, except his nickname, and that of his father's name was correctly written in the charge sheet. And the plaintiff was arrested by the respondent number 3 oblique defendant number 2 more than 2 years after filing of the charge sheet and the transfer of the appellant to a different station. In the opinion of this court, the same question of law does not arise in view of the fact that there is no such pleadings in the written statement. Be that as it may, this court also finds it very relevant to take note of that the defendant number 2 and 3 are officers in the police department, and as such, they have to be responsible in their conduct in as much as the same, and if they are not responsible, the same has the effect of taking away the liberty of a person, which have been done in the instant case. In the opinion of this court, the learned trial court or the first appellate court ought to have awarded a much higher amount than what had been decreed. Be that as it may, as there is no cross appeal filed against that, this court is not in a position to enhance that amount. The second substantial question of law so formulated in the opinion of this court also does not arise in the instant appeal. for which was accordingly the appeal stands dismissed with cost quantified. Did he appear at any point of time earlier?
Yes.
Quantified at rupees 11,000. So further to that, the plaintiff would be entitled to the cost throughout the proceedings. LCR return.
I mean, one thing is there is vigorous liability, so state government should pay the amount.
Go and approach the state. I can't direct. I have mentioned one word of in that while deciding issuing a substantial question number 1 or I have said that the state did not find. I'll add one line if possible as regards the payment because of the fact that say the state legal is dismissed. In view of the dismissal of the instant appeal, not only the appellant herein, the state of Assam, who is the defendant number 1, is equally responsible for payment of the decretal amount.
I will make one prayer in this case. Right? One prayer.
Yeah.
In 1 week time may be granted by us.
For what?
I need to test out my brief. I need to test out my brief.
Give me, take my that file. Whether in view of the fact that after the date of agreement on demand, the plaintiff proved the defendant only on one
Yes, yes.
12,000
Yes, sir.
per challenge for execution. Yes, Mr. Mazumdar. What is this case?
Significant arises that were filed by the plaintiff respondent hearing for specific purpose of contract.
Hmm.
Now, the agreement was executed on 27th of January 1994.
Hmm.
And it was filed in 2004.
Huh?
2001.
Show me that, plain.
Plain. Lordship. Possibly.
Monus Polita.
Yes.
Suit for specific performance.
My lord. But unfortunately, when the defendant files a written statement once, then plaintiff finds that some other legal errors are there of the original person's will take to them. So other persons were other siblings of the defendant number 2 were implicated. They filed again a written statement, second. And thereafter the defendant number 2 filed a counter claim. And of
We
course,
are the plaintiff.
I am for the defendant.
Hmm.
The second substantive question of law has been framed, possibly not been relevant because question of title will not arise here.
Suit for specific performance of the contract and for permanent injunction.
Yeah.
Specific performance of the agreement for sale.
My Correct.
So 27,194.
Yes.
Why was the suit filed in 2001?
I thought in between, possibly even in the pleading also, they have been fighting about possession of the suit property.
Possession has no relevance.
No relief. Now somehow even the written statement also covered majority of the paragraph covered the question of possession. What happened, my lord?
Where is the agreement?
Exhibit 1
What was the stipulation in the agreement?
Stipulation in the agreement subject to correction, my lord, is of not very relevant here. What is relevant here is, my lord, in the written statement we have taken one period part by name.
That is what I'm saying.
My lord.
What is the stipulation in the
That-
agreement?
That is not there. Within what time it has to be executed is not.
No. Something has to be mentioned. You see, there are two parts of 54.
Right.
The first part is where the period is mentioned,
And
it is
second-
okay.
Second part
And the
is not
second is when he has due
Refuse.
notice.
notice of refusal.
Notice of refusal.
Right.
Now, is there a mention
Right.
that there is a requirement of taking some permission? Why did he approach after 2000?
He has taken a plea in the play that since there was a dispute because of possession, not with him. So it was not possible to execute the sale deed that is why after 145 proceeding was concluded and possession was delivered to us, that is the defendant vendor. Then he approached us and then we
That can't be the ground. Well, therefore, the sale deed, agreement for sale is relevant. Let's see.
well, it's there in the record when I'm speaking.
Mr. Sharma, give in the file.
And from the pleading itself, from the plaintiff's pleading, I can comment this part by time. He said, after the death of the vendor, the defendant number 2 was unwilling to execute the sale deed. That
Hmm.
vendor died.
Where is the statement?
Lot will find a page, paragraph 4 of the plain. 5, I'm sorry, 5. During the pendency of the state proceeding, if the document is got under section 145 CRPC, it was not possible to execute and register the sale deed. In the meantime, late Rudreshwar Sharma expired on 29/7/1996. After death of late Rudreshwar Sharma, his son Kailash Sharma was not willing to sell this land to the plaintiff. Now there is one
And he had initiated false criminal cases against the plaintiff, about which the plaintiff could come to know in the year 1999, when the police came to him and granted him bail.
if the second is power of attorney.
And this case was
not
to the plaintiff after disposal of him. But then, and after the intervention of some mutual friends and well-wishers, the principal defendants agreed to sell the land as per the agreement to the plaintiff after disposal of the case number 148 M/95. Okay, now you must have cross-examined him. Okay, I'll see.
I was looking for confirmation on this point. Some more exceptions. It's very difficult to usually document can be happen. Proceed.
Yes, Sharma,
I,
civil judge.
I don't want to.
Is it? Huh?
Yes,
There is a word by which we explain this kind of script. It's very difficult to obtain.
There used to be a called a bench clerk or something who could read his handwriting.
His own bench.
Huh?
His own bench clerk.
No. He and this suit was filed in the trial court, na? In the Munsif, na? Munsif 1? 1 or 2?
Firstly, it was in civil court. Thereafter,
Later
on,
No, where was the recording done?
Recording
civil
was
judge. Civil judge.
3.
I applied for certified copy. For copies could not read the words. We just to approach to the court. Just say that you have approached to me after 5 days. How can I read that?
Okay, then.
Sir, possibly my first step will be, Your Lordship, gives me opportunity to argue on this question of limitation matter.
I'll permit you. But
Uh,
the question is,
re-
how do I do it?
Reframing is necessary, possible.
Huh?
Reframing of this substance question from number 1. Or framing of.
Let us see how does the trial court look into it.
Trial court has simply said, in fact, going by what we have stated in the written statement, that from the date of agreement, either 3 years from the date fixed for execution of the sale date, and if no date is fixed from the date of.
Number 2. Had period the suit is barred by law, and the learned counsel argues that for a suit remand. Now from exhibit 1 it transparent that no date was fixed for performance of the contract, therefore the date when the plaintiff has notice of it. The plaintiff's case is that it's only in so and so, and finally on remand when he refused the performance of the contract, the suit filed on so and so is thus within time. The defendant's argument is that how does it take into account the evidence?
Neither the evidence nor this part of the pleading of the
When the filing of the suit on the accusation brought by the defendant against the plaintiff was that later has caused the power of attorney in the name of the former. Case. Wait. In the present suit, so far as the filing of the case is concerned, the acquisition of the it was that later had caused the power of attorney. First information was same day as case of the court was of Exhibit 1 को तो They have not challenged the deed of sale, the deed of agreement.
Agreement.
They have not challenged.
If the counterclaim there is only for declaration of right at least. Declaration of right at least.
But this agreement has nothing. You can't raise the point of limitation. Whenever it will see the wording used.
Yes.
Now this indenture witnesses as follows due to some unavoidable circumstances.
Yes.
It is not possible from both the parties to draw up a sale deed, and due to this reason, both the parties want to enter into an agreement for. That is why I say,
Agree with that.
with this deed of agreement, you can't do anything. What is your substantial question of law?
The first one will be
Limitation goes for a 6. With this agreement, how do you have a limitation? In view of that, after the date of the agreement on remand, the plaintiff approached the defendant only on remand, offering balanced amount for execution of the. This does not arise because this aspect is wrong. His case is very specific that there is a land dispute which is going on. He could not, and thereafter you file some criminal case against him in 95, 99. He was arrested, and thereafter he knew, and there has been then mutual agreement, and he filed the suit.
So arrest was connected with different things, not in connection with any.
This is for ready and willing. He is willing to pay.
Alert.
Has he made the statement in his claim that he is ready and willing?
Was at least
And in his evidence, did he say that he is willing to pay?
stated-
This goes. Number 2 is whether having come to a finding the defendant has a title to the suit property in issue number 9,
question of framing this issue. If plaintiff
the
is
appellant
divided,
court was justified in reversing the same and dismissing the counterclaim in a suit for specific performance. How is this relevant?
Right.
Nothing. You don't require the fact. We dismiss it right away.
I ask the question of limitation on the ground.
You can't help, Mr. Mukunda. The problem arises. This deed ought to have been challenged.
However, there is the first question that we asked whether that in the counterclaim, instead of saying for declaration of title, there could have been that the agreement is bad, he, that. That's not it. But well,
I have come across many of these type of deeds earlier, the lawyer. These deeds are mostly made with some people who will be taking on. The face of it is clear. It is challenged and it- And that is why you gave a FIR.
but FIR was in the totally different. The FIR was that stating that there's a power of attorney which he got executed and signed by his mother, dependent on his mother and father. And this issue was discussed here for the purpose of deciding the question of limitation. Because we say that it is part by limitation. The finding of the court is, and we also say that you had notice of intention of refusal from the date we lodged the FIR. According to the court, no. When he was arrested,
He knew. That is what the trial court held.
that is fine. My submission, if we go by the Limitation Act, it has to be either within 3 years of the date this big court decree.
Nothing is. That is the problem. The sale deed, the agreement for sale, I've never heard of like this. And when it says that there are problems for which we have just entering into it,
But
either language can't help anywhere.
But the second part, if there is no date, when Lordship kindly see, if there is no date fixed,
From the date he has knowledge about the refusal.
the refusal. Now, refusal according to the plaintiff himself, my lord, in my humble submission, that after father died in 97, 96, para 5. Yes. 29th of July 1996.
So did you not cross-examine him on that aspect?
That part I all the difficult
Just find out that, because your idea is this.
Right.
Once the limitation starts,
Right.
it does not end. It cannot end like this. I mean, you cannot again restart.
No.
So if the limitation has started in 1996, in view of that state, did it happen in 99? It would have ended. How could you have filed a suit in 2001? Understood. But without that cross-examination being pointed out to me, why will I frame an additional substantial question on
try to read it with it. What's it? Difficulty.
Mr. Ganguly? That day, that matter, you remember? That lady, there's a second RSA, you said that 10 times some adjournment was taken. That's you, na?
Yes.
He has filed a review application. I've asked her to give a copy to you. It is on next Friday. Reconsider it.
I'll try to read to you. Take it up.
As of now, there is no nothing.
Process is very difficult to read.
And Mr. Muzumdar, without even the brief of Mr. S.J. Sharma,
Right.
your appeal is now just going down the drain. And remember, if I defer the matter, he will have a brief. Then nothing will remain. He will just put the death nail. He may ask for execution.
Try to read it.
Hello. Please, the matter having been heard at length, the matter will be listed again on Tuesday next at 2 p.m. Problem arises there, no way. Oh, Mr. Mazumdar, today I could upload the judgment. I had a problem with some medical problem for which all these days here. I have made it very clear out there that you will be entitled, they will be entitled to interest, free suit interest from 13/11/2001 to 12/3/2003. That is 16 months. At 16.45%, I made it further clear that it is not a compound interest, it is a simple interest. Apart from whatever judgment I've done, I've also dealt with the judgment to that effect. On that day, they couldn't get the time. So I dealt with the judgment and said that this is an exercise of jurisdiction done under 142, when the Supreme Court was dealing with a matter pertaining to the polluter pays principle. And as such, the principle of restitution was taken. And secondly, I dealt with another recent judgment, which is the Sunita Agarwal versus Amrit Merchant, 2023, wherein it was an issue pertaining to whether the consumer forum could grant compound interest. The Supreme Court say that in a suit for recovery or a matter for recovery of money, compound interest cannot be given. Compound interest would be in the form of damages, which will be different. So that aspect I brought in. Yeah. So that is the matter here. And I've asked you on 29 to give you a calculation.
Yes.
I also held out there, which was not there on that in view of the compound interest being taken into account by the learned executing court, as well as the manner in which he had taken 18% out there, all these things would show that the decree which was being passed was beyond the jurisdiction and exercise was with material irregularity, for which I set aside the judgment.